determination as to whether the individual defendant is eligible for bond. If the individual defendant is eligible for bond, the court is then going to set bond release conditions that specifically apply to the listed individual defendants. The court is not going to touch out-of-county holds, out-of-state holds, or sign warrants on violations of probation, which actually, for the most part, should no longer be on this docket, or KPSs for the most part. If you are a civilian, please pay attention because this applies to you. If you're a civilian and you are on these proceedings, please note that not only are these proceedings recorded, but they are live streamed on YouTube. So for that reason, and for security purposes, you need to have your camera off and yourself muted until the case that you're here for is called. You would indicate your presence by using the raised hand icon. Once the court does acknowledge your presence by seeing that you have raised your hand, I will then make a determination as to whether you are the listed victim. If you are the listed victim, I will ask you a line of questions regarding whether you wish to be heard from or whether you're just here to see what happens. If you do wish to be heard from and you're the listed victim, then I would move on to swearing you in. If you're anyone other than the listed victim and you are here, you need to be called on by one of the attorneys in order for me to hear from you. Please do not interrupt these proceedings by either, again, by turning your camera on as a civilian or unmuting yourself and interrupting these proceedings. Depending on the severity of the interruption, you could be ejected from these proceedings without warning, or the number of times that I ask you to keep yourself muted or keep your camera off. That being said, I do have to take a couple of cases out of turn, more than a couple. I do have to take certain cases out of turn based on medical reasons and or the charges as they are listed, and for attorneys who are not assigned to this courtroom. I am calling on attorneys who are not assigned to this courtroom because they have other places and other courtrooms that they need to be in. I'm doing it as a courtesy. Please do not think that I am giving them any other courtesy other than calling on them because they have other places to be, and I'm allowing them to go to their courtrooms that they have to appear in versus the attorneys who are assigned to my courtroom. All right, so that being said, let's start with our let's start with main jail since Mr. Weathers is still talking. So let's do my main jail out of turns. Mr. Romero, they asked that we take Mr. Keller on page 17 out of turn at me. Actually, yes, Mr. Keller on page 17. I don't, oh, okay, I see it. All right, Mr. Keller, good morning, sir.
Morning, ma'am.
The court does find probable cause for petty theft, second degree, third or subsequent offense. Hold on, mute this. So Mr. Linder, first to you.
Recommending ROR to pretrial and overturn.
All right, thank you, Mr. Romero.
Judge, no objection. That's exactly what we were seeking. We're just going to be asking to be provisionally appointed on Mr. Keller's behalf, Judge.
All right, thank you. All right, Mr. Keller, I am going to release you to pretrial release. That means that you're going to get out today, but you have to call in tomorrow morning before 11 a.m. Please provide your phone number to pretrial before I continue with my orders. He's muted.
House line 954-968-7754. It's been the house line for 30 years.
Okay, did you get that, Ms. Brown?
Yes, sir.
All right, I'm stopping the video for this iPhone who didn't listen to my instructions. If I have to turn your camera off again, I'm ejecting you from these proceedings. All right, sir, you cannot return to the Walmart in the police reports. Do you understand?
Say that again, ma'am?
You cannot return to the Walmart in the police reports. Do you understand?
Okay, no problem.
All right, and I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Keller. Once COVID is over, you will need to reapply officially through the clerk's office to make sure that they keep representing you if this case is still pending. Good luck to you, Mr. Keller. Call in tomorrow.
Thank you. All right, thank you.
All right, next is Mr. Carmel on page 18 that they also asked we take out of turn.
Judge, Mr. Harmel is a little bit hard of hearing. We're going to try to be extra quiet here at the jail so he can hear you as you speak to him and address his case.
Okay, thank you. Mr. Harmel, good morning, sir. Can you hear me?
Yes, I can. Good morning, Judge.
Good morning. Yes.
FYI, he has already posted bond on counts 1 and 2.
Okay, thank you. So I have just been informed by Ms. Cooper that bond has been posted on counts 1 and 2, but not yet on 3 and 4. So I do find probable cause. Count 1, defraud financial institution. Count 2, fraudulent impersonation, use ID of another without consent, over $5,000. Count 3, fraud, uttering a false instrument. Count 4, grand theft, over $5,000, but less than $10,000. Mr. Linder, first to you, sir.
Your Honor, if I can inquire, is there anything indicating who's supposed to bond? It's bonds and it's likely that the other two bonds are.
Judge, unfortunately, we couldn't hear anything.
He was notified, well, what happened at the time of booking? At the time of booking, they only booked counts 1 and 2. And then they had to come back and book 3 and 4, and they called the bond and let them know the truth is no charge.
Based on that, that's enough to keep the bonds in place.
Okay, thank you. So Mr. Linder asked for the bonds to be left in place because the bondsman notified us that at the time that he was booked, only counts 1 and 2 were booked in, but later on counts 3 and 4 were booked in. So that is the reason the state asked for the bonds to remain in place. Mr. Romero, to you.
Judge, no objection. That's exactly the information I found out from the deputies, that the bonds on 2 of the 4 counts were posted. The other 2, because I guess they were processed later on or something like that, they haven't been. I'm going to contact his father to go ahead and post the remaining of the bonds. I'm not going to be asking to be provisionally appointed. My understanding is his family is going to retain private counsel for Mr. Carmel.
Okay, thank you. All right, sir, I am going to leave your bonds in place, but you cannot return to the check cashing store and the police reports. Do you understand?
Yes, sir. Yes, ma'am. Yes, ma'am.
No problem. You also cannot have any contact, direct or indirect, with the listed victim. Do you understand?
I can't have what? I'm sorry.
Contact with the listed victim.
Okay.
Okay, that means that you may not know who they are, but you cannot call, text, email, social media, have a family member or friend send a message to them, or any other means of communication that I have not said. Do you understand?
Yes, I understand.
All right, thank you. Anything else on his case?
No, Judge.
All right, good luck to you, sir. All right, next on page 21, Mr. Johnson.
Mr. Johnson, come on up, please. Approaching.
Yes, sir.
May I just have a moment to read the PC for this?
It's a change of charge from an attempt murder in the first degree to an attempt murder in the second degree. It's not in the packets, Mr. Weathers. He was previously magistrated on 6/1.
Okay.
It should be an Odyssey though.
The only thing I saw in Odyssey, Mr. Linder, was the additional bat video that didn't actually upload the attempt murder.
All right, let me check that, Your Honor, one moment.
And Judge, correct me if I'm wrong, now it's a bondable offense?
It is bondable now, but we need to have, actually, the PC is here, sorry, it's second. It's, if you scroll down, it's in Odyssey, Mr. Weathers. So Mr. Weathers does need an opportunity to read through it. So what we're going to do, Mr. Johnson, we're going to put you on a brief recall since this is now a bondable offense, so that your attorney, Mr. Weathers here, can take a look at it and see if he has any argument based on what's been provided, okay? Okay, no problem. Have a seat, Mr. Johnson. I promise we'll come back to you. All right, so next is Mr. Sears on page 16.
Judge, Mr. Sears is here this time. We're going to be waiting for reading of the charges.
Mr. Linder, you're not muted.
Sorry, Judge.
All right, yes, okay, thank you. So the court does find probable cause on counts 1 and 2. I am deeming him a danger to the community based on the fact that he is a registered predator. Mr. Linder, what is the state's recommendation on counts 1 and 2?
One moment now.
I saw that there was a 1998 conviction for 3 counts of sexual battery with weapon or force, that he served 14 years Florida State Prison, and a kidnapping, as well as a 2010 failure to register as a sex predator. Anything else in the state system?
No, Your Honor, that's all I see. Based on that, Judge, I'm recommending a $500,000 bond on count 1. Asking that you keep the bond that Judge Usan set in place on count 2. Judge Usan had, it looks like you put GPS level 1 on count 2. I'm just asking that to be applied to both counts. No victim contact and no return. Nothing further, Judge.
Thank you, Mr. Romero.
Mr. Sears is not working. He is homeless. He is financially indigent. At this time, Judge, we're just going to be asking to be provisionally appointed and invoking his right to remain silent, not be questioned by law enforcement prior to first contacting his assigned attorney, Judge.
All right, thank you. Based on the randomness of this act, I am deeming him a danger to the community. I am going to set bond in the amount of $1 million on count one. If he's able to post bond, he's going to be supervised by pretrial release level 1 with a GPS, that's strict house lockdown based on the randomness, the threats to kill, and the other allegations I put forth on the record. You cannot return to the incident location, Mr. Sears. Do you understand?
He answered in the
You cannot
affirmative.
have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
That means even while you're in custody, you may not know the listed victim, but you cannot call, you cannot text, send letters, have a family member or friend, or any other means of communication that I have not said. Do you understand? You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure that they keep representing you. Anything else on Mr. Sears?
No, Judge.
And I left the bond in place on count 2, just so it's not confusing. All right, thank you. Next is Mr. Burgos on page 17.
It's approaching, Judge. Judge, we're going to be waiting for reading the charges.
Burgos on 17. You're waiving reading?
That is correct, Judge.
All right, thank you. So I do find probable cause for the single counts. I am deeming him a flight risk based on the allegations, the date of the incident. Mr. Linder, hold on, let me mute this first to you.
Your Honor, I'm asking that the court make a finding of proof evident and presumption great. This is a light felony based on the alleged use of great force.
So hold on a second, because the actual findings are different. The findings are not a PBL, so we need to change the findings.
What did the findings say, Your Honor?
They waive formal reading, so how can I address it?
Yeah, no, I mean, all I can tell you, Your Honor, and it should be, I did pull the information.
You need to address it, Mr. Romero, because
Yeah,
it's not accurate. The findings are not accurate. I'm looking at the findings.
Judge, we can go to a breakout room if you desire.
Because it needs to be on the record. It's not a sealed petition. It's not a sealed warrant.
Correct me if I'm wrong, we've done this past and it's still been on the record.
It's not on the record when we're in a breakout room.
Judge, at this time, we're still maintaining our request as far as waiving formal reading.
All right, so what I can do is I can say that the court finds probable cause based on the information that's been filed by the state, and I'll make those findings as opposed to what is listed in the findings. So I'll print a copy out for you if you need it, Ms. Cooper. Do you need a copy?
No.
Okay,
We have on the, based on the statute, they put in the comment. Do you have a booking sheet?
hold on.
It should be in the comment section on the booking sheet.
Page 31, packet 3. Just give me 1 minute to scroll there.
I can make you a copy.
It's fine. I just need to make sure it's accurate on the booking sheet.
And then you can match the findings for,
The comments are correct.
okay, let me give you this.
All right, thank you. All right, so I am making a probable cause finding based on the information that's been filed, so we can alleviate that concern. Mr. Linder, my apologies for cutting you off. You may proceed.
That's fine, Judge. Your Honor, I'm asking that the court make a finding of proof evident or presumption great. I don't know if you want me to wait, allow if Mr. Weathers has any argument for the court to make a determination before I proceed to bond request, Your Honor.
I am going to make a finding of proof evident presumption great based on the allegations, based on the level of violence, the randomness of the act. I am going to hold him no bond at this time. We'll have to file a motion for an Arthur hearing with his division judge. And Mr. Oh, you guys lost video. All right, so Mr. Burgos, at this time, I am going to hold you no bond. You're going to have to file a motion for an Arthur hearing with your division judge. You cannot have any contact with the alleged victim, direct or indirect. Do you understand?
Yep.
You may not know who they are, but you cannot call, text, email, send letters, have a family member or friend send a message to the listed victim, or any other means of communication that I have not said. Do you understand? Mr. Linder, are there any other conditions that the state is asking for?
Just no, and I apologize if Your Honor just ordered it. No, I just asked for no weapons.
Okay, and also, sir, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? Sorry, was that a yes?
Yes, ma'am.
All right, and Mr. Romero, does your office need to be appointed?
Yes, Judge, and I'm also going to be requesting a medical screening and a mental health screening, Judge.
All right, not a problem. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. I will sign that mental health screen and medical screen. Anything else?
That is all, Judge.
All right, thank you. All right, so that's Mr. Burgos. Okay, so
Okay, Judge, we could go ahead and address the page 21, Mr. Johnson.
Mr. Johnson, okay, so let's recall Mr. Johnson on page 21.
If Mr. Linder has the bond amount for Mr. Johnson.
I haven't made my finding yet. Let me do that first.
Excellent.
All right, so Mr. Johnson, good morning, sir. The court does make a finding of probable cause for an attempt to murder in the second degree. This is now a bondable offense. Originally, he was being held no bond, as this was a no bond offense of attempt murder in the first degree. So Mr. Linder, first to you for recommendation and any priors.
Your Honor, based on I don't see any history. Based on the level of violence, Your Honor, the randomness of the alleged act and the injuries suffered by the alleged victim, Your Honor, I'd be asking for a $100,000 bond, pretrial release of the GPS monitor, level 1, no victim contact, no return, no possession of any firearms, weapons, or ammunition. Nothing further.
Your Honor, before my colleague, Mr. Romero, addresses the other factors in the bond amount, just as to the nature of the circumstance here, the level of violence in the face of the self-defense by Mr. Johnson was noted in the PC affidavit. The relationship between him and the complainant, Mr. Molina, if they're family friends, they were close friends. I think that there has to be a bit more that has to be brought out and fleshed out of this incident. And I would say that the next step would be for Mr. Romero to address the other factors. Thank you, Judge.
All right, thank you, Mr. Romero.
All I can tell you is that this Mr. Johnson's been in custody for quite some time. Prior to him being incarcerated, he was unemployed. He was looking for work, wasn't successful. He lives with his grandmother. His grandmother, they're on housing. She's Judge, my understanding, his grandmother collects disability, so he's financially indigent. I'm asking you to take that into consideration, determining reasonable release conditions for Mr. Johnson.
All right, thank you. Based on the allegations that this allegedly happened on a bus where there were multiple witnesses that indicated that he was the alleged aggressor that allegedly stabbed the victim in the abdomen, who had to be transported to the hospital. I am going to set bond in the amount of $100,000. This can be reviewed by his division judge, but this is my ruling today. Once he posts bond, he's going to be on pretrial release level 1 with a GPS. That's strict house lockdown, meaning that you cannot return to the incident location, Mr. Johnson. Do you understand? I can't hear you. You also cannot have any contact with the alleged victim, direct or indirect. Do you understand?
He answered in the affirmative, Judge.
Okay, thank you. That means no phone calls, text messages, emails, social media, letters, or having a family member or friend send a message to him or any other means of communication that I have not said. Do you understand?
Yes, ma'am.
You also, oh, sorry, I heard. You also cannot possess any firearms, weapons, or ammunition while your case is pending, and that includes knives. Do you understand? I couldn't hear that one.
Yes, ma'am.
All right, thank you. And Mr. Romero, your office has already been appointed. Is there anything else on his case that we need to address?
No, Judge.
All right, Mr. Johnson, good luck to you, sir. Right. Are we able to date the Spanish interpreter cases before we move on to our private attorney cases, or?
Yes, we have. Judge, I know the deputies would like to see if we could address Malik Petit-Frere. He's on the second look docket.
Oh, yes, thank you. My apologies. I did miss that one out of turn. So let's do Mr. Petit-Frere on the second look. All right, good morning.
Good morning, ma'am.
All right, Mr. Linder, this is a second look on a battery. I believe I remember the allegations. Was this a random act that occurred allegedly earlier this week?
One moment, Your Honor.
And I see Mr. Ducko is here in the courtroom. So are you here for Mr. Foster on page 16? I'm just checking you in. I was advised by Mr. Linder at the beginning of the docket, so I pulled your case. Okay, yes, thank you. So I do have you checked in. Guys, for some reason, the podium is muted.
So, Your Honor, the allegations in this case were that he was advised that he needed to move his car where it could be towed by Advanced Auto Parts, and he walked up to the victim unprovoked, punched the victim in the mouth. This was recorded on video surveillance. Additionally, the court took into consideration that this could potentially be upfiled to a felony battery based on Mr. Petit-Frere's 2018 battery. He actually had two separate batteries in 2018. He also had a resisting without violence in 2019, resisting with violence in 2018. Nothing further, Judge.
All right, thank you. So Mr. Romero, has anything changed since I set bond approximately 1 or 2 days ago?
Judge, at this time, clearly, what he told me, advised me that no one could pay his bond is true, as evidenced by him remaining in custody, Judge. I believe, my understanding of speaking to Mr. Petit-Frere earlier today, once law enforcement was called, he remained on the scene. Judge, this is a misdemeanor offense. I know he lives in Lauderhill. He has a place to stay. He lives with his mother. Judge, we're going to be asking for the court to reconsider and release him on pretrial release. If the court's not inclined, we're going to be asking the court to consider releasing him on level 2 at this time.
All right, thank you. I'm going to take no action based on the at least 2 prior battery convictions I heard. As I already informed him, he could be charged with a felony, and the $1,000 bond is taking into consideration what it's been presented as. If it's presented as a felony, it could be addressed at that time. Good luck to you, sir. I'm taking no action. All right, next, let's see. Oh, who do you have in North Broward that needs a Spanish interpreter? I can put you in a breakout room with the Spanish interpreter. If you want me to do that, then I can do the private attorney cases. So, Mr. Interpreter, are you there, sir? Good morning again.
Yes.
Can I send you to a breakout room with North Broward so that I can, Mr. Weathers from the Public Defender's Office can speak to his client, Mr. Sanchez?
Sure.
Thank you. What page again? Page 14, Mr. Sanchez. Okay, so let me set North Broward. I can't hear you.
Your Honor, by the way, do we have a case number or arrest number for Mr. Sanchez?
The arrest number is 502-101-398. I don't know.
Okay, thank you.
Do you want to step outside and call in on Zoom and do it that way? Yeah. So do you want me to send them now? Okay, all right, so let me, and then where's North Broward? All right. Technology. All right, so we're gonna try that. All right, so let me start with, so while our Spanish interpreter is gone, let's start with our, I did my check-in, so let's start with Ms. Davis on page 4. Ms. Zolnor is here on her behalf. Mr. Weiner is here on behalf of the state.
Good morning, Judge. And Judge, Ms. Davis's sister is also on the line. It's Sharon Krum.
All right, thank you. Did you intend to call her as a witness?
If it becomes necessary, Judge, I can proffer what she would testify to make it easier. And also we would waive formal reading.
All right, thank you. So, thank you. I do find probable cause on count 1. On count 2, it says with license suspended, Mr. Weiner, but it says also in the police reports that she was never issued a driver's license. So,
Correct, Your Honor. It should be driving without a license causing death. It should be subsection A, not subsection B.
okay, so without license causing, okay, thank you for that clarification because I could not find probable cause as it was presented. Okay, and I do find PC then as the amended count 2. Does Ms. Zollner, does the defense have an objection?
No, Judge.
All right, thank you. On 3 and 4 as presented, defense having waived formal reading. I am deeming her a flight risk based on the allegations that she left the scene. So Mr. Weiner, first to you, then I'll go to Ms. Zollner.
Yes, Your Honor. Your Honor, as far as any prior history, there is no prior criminal history that we can locate. As far as the other factors the court has to consider for bond under 903.046, besides information in the probable cause affidavit, Your Honor, this crash occurred on June 28th. Subsequent to the same night of the crash, the defendant and her boyfriend took the vehicle. They ditched it on the side of the road with the caved-in windshield, which Your Honor had a chance to see in the video. They then wiped the vehicle down with bleach to avoid having law enforcement locate the vehicle. She then had her cousin, who's the registered owner of the vehicle, call Sunrise Police and file a stolen vehicle report. The police were looking for the vehicle for over a week. They finally spoke with the owner of the vehicle, who told the police that it was actually Miss Davis who was driving the vehicle at the time and had her file that report to avoid being caught. When Miss Davis was spoken to by the police, she confessed that not only did she cause the crash and flee the scene, but she then went home, contacted her boyfriend, who then came to the house, went with her to where and they then ditched the car on the side of the road, and they failed to report the crime. Ms. Davis also did not have a license at the time. She's never had a license. So based on all of those facts, Your Honor, I'm going to start with count 3, just because that's the most serious charge. As to count 3, the state would ask the court to set bond at $100,000 to be fully collateralized with pretrial level 1 with a GPS monitor, special conditions that she not drive or get behind the wheel of a motor vehicle, and that she not leave Broward County, as well as surrender any passport or passport card in her possession prior to her release, and not apply for a new passport. As to count 4, vehicular homicide, $75,000 to be fully collateralized, same conditions as count 3. Count 2, driving without license causing death, $25,000 to be fully collateralized, same special conditions. And count 1, tampering with evidence, $10,000 to be fully collateralized. Total bond amount requested is $210,000.
Okay, thank you. Ms. Zollner.
Judge, I had an opportunity to read the PC and take a look at the photos that Mr. Weiner sent to me. There is no, I have not had a chance to speak with Ms. Davis, so this is coming from me. I'm not speaking for her or making any admissions on her behalf, but from what I read, it sounds like someone who got really scared and made some bad decisions. She has 0 priors, Judge. She's in high school. She's 17 or 18 years old. I know of her through someone who is very close to me, and I know that she's a good kid. She takes care of her elderly mother, who literally almost just died a couple of weeks ago. She's the only person to take care of her. I would also, offer to the court that I don't believe she's a flight risk, although she made a bad choice that evening from what the PC reads. She doesn't even have a passport. She has no family in any other state or county other than Broward. And she doesn't have a large network of family either. It's just her mother and her sister. Her sister is not available to care for her mother, as her sister has 2 small children and is pregnant with a high-risk pregnancy and is bedridden. She can't take on her mother, and there's no room for her in her home for her either. So on top of being a high school student, she also works at KFC. She has never been in trouble with the law before, Judge. I don't believe she's actually a flight risk because of the allegation that she left that evening. I understand the need if the court wants to impose GPS, totally get it. But the $210,000 bond fully collateralized is not a possibility. It's not a reasonable possibility at all. No one owns a home to put up. No one owns any property to put up. There's no money for that, Judge. I believe that the GPS would negate the need for a high bond. I understand the need for a bond, but the purpose of a bond is to ensure her presence at future court hearings. I know this person. She's not going to flee. She's hiring counsel in order to represent her in court. She's presumed innocent at this point, Judge. So if the purpose of the bond is just to ensure her appearance in future court hearings, I ask that the court consider lowering that bond significantly. I don't know that they can even, they would, because they have no collateral, the family, they would have to essentially crowdsource this money. I would ask for 10% of that, Judge. I don't think that they could get their hands on more than $20,000. I think that the GPS level 1, putting her essentially on house arrest, will ensure that she will be present for all future hearings. I will be present for future hearings for her. I don't believe that she poses a risk to the community, or that there's any record evidence that she presents a risk to the community, because this is one isolated incident. This is not a pattern of behavior. There's no evidence that this is a pattern of behavior. She doesn't even have a traffic record, Judge. She doesn't have a driving record. I understand that she doesn't have a license, but there's also never been any other reports of incidents with her speeding or doing anything like this, Judge. So I am asking for her sake. She's an 18-year-old girl, a 17-year-old girl who's never been in trouble a day in her life. And for her mother's sake, I'm asking that the court consider lowering that bond significantly. I don't believe that they could get together any more than $20,000. And I think that the GPS level 1 would render the need for a high bond unnecessary.
Thank you, Ms. Olner. Is she still in school?
Yes, Judge, she's in high school. I believe she's going into her senior year.
Okay, thank you. The purpose of bond is, in addition to ensure the appearance of the defendant at subsequent proceedings, it's also to protect the community against unreasonable danger from the defendant, which is the purpose of Florida Statute 903.0. So I understand your position that it's as to appearance, but in addition to appearance, sir, you need to keep your camera off. This is the 3rd time I'm doing it. If you log on again with your camera on, I will eject you from these proceedings. Ms. Zollner, Ms. Davis, Mr. Weiner, I apologize. That is why I ask people to listen to my instructions. Okay, so based on that, I also am taking into consideration she is a high school student with no priors. However, based on these allegations, they're very serious. It's alleged that she allegedly ran over a pedestrian, fled the scene. I am leaving the findings that she is a flight risk, and the alleged victim died. And then it's alleged that she and her boyfriend tried to clean the automobile that they abandoned with bleach to destroy evidence. So I am going to set bond on count 1. I'll leave in place, but on count 2, I'll set bond at $25,000. Count 3, $50,000. Count 4, $25,000. And I know that the state asked for it to be fully collateralized. I'm not going to do that at this time because of the other factors that I put forth on the record. She's a high school student, 18 years old with no record, but she is going to be supervised by pretrial release level 2 with the GPS so that she can continue to go to school with a pre-approved schedule. I want to make sure that she still goes to school, but ma'am, you cannot drive while your case is pending. Do you understand?
Yes.
Okay, you also cannot leave Broward County without a court order, okay?
Okay.
All right, and does she, you indicated she does not have a passport, Ms. Zollner. Can she get an affidavit to that request, to that point then, to submit to the clerk of court within 24 hours of her release? Oh, you're muted. You're still muted, Ms. Zollner.
Judge, I have like third hand knowledge of this, so I believe she does not have one. So if that information ends up being accurate, I will provide an affidavit. I'll supplement the court file, and if she does have one, we will turn it over.
Okay, so I will order within 24 hours of her release that she shall either surrender her passport or provide an affidavit to the clerk of court, a notarized affidavit that she does not possess one and she cannot reapply for one while her case is pending. Is there anything else on Ms. Davis's case that we need to address?
Your Honor, just to clarify, so it's 1,000 on count 1, 25,000 on count 2, 50 on 3, and 25,000 on count 4?
Correct.
Okay, I will prepare the order, send them to Ms. Zollner, and then forward them to Your Honor for your signature.
Sorry, was that 1,000 or 10,000 on count 1?
1.
Oh,
Thank
Thank
you, Your
you.
Honor.
All right, take care, Miss Davis. Stay in school.
Thank you, Judge. Thank you, Mr. Weiner.
All right, thank you, Ms. Zollner. Thank you, Mr. Weiner. All right. Oh, sorry, I didn't put the time frame. Within 24 hours of release. Sorry about that. All right. So next is Mr. Striegels on page 17. Is Mr. Jaffe there?
I am, Your Honor. Good morning. Attorney David Jaffe on behalf of Mr. Striegels, who's present before the court. Your Honor, would you like me to proceed?
No, just give me 1 minute because I have to make my probable cause findings. Hold on 1 minute. All right, Mr.
Certainly.
Striegels, good morning, sir. The court does make a finding of probable cause. Let me go to the page so I can read the charges. All right. Count 1, lewd and lascivious molestation of a person. Actually, Mr. Linder, I don't have her age, so I can't make that finding yet.
Your Honor, I checked my reports this morning. The alleged victim's date of birth is 9/8/07. The initials are ZS.
ZS?
Yes.
And what, so how old is she? Math.
That would make her, I don't have the incident date in front of me, but right now she would be 13.
Okay, thank you. So based on that, the child's age, okay, so she was 12 at the time.
Your Honor, I believe she would be.
She was 13 at the time or 12?
12 at the time, Your Honor. Date of incident, according to the information, was that the incident occurred between July 1st and July 31st of 2020.
What's her date of birth? Because the findings say that she's less than 12, so we need to make sure these findings.
Yeah, it's Your Honor, her date of birth is 9/8/07. I can also advise the court, reviewing the probable cause affidavit, that the molestation count, it's between 12 and 16. The exhibition is victim under 16, and also the conduct charge is with the victim under 16.
Okay, so the findings are wrong, so that's why I needed to make that clear. That's why, I don't know why these are always incorrect, so just give me 1 minute.
Again, they put it in the comments, because when they come in on the statement, there's no actual statute on the statement. So they'll get as close as possible and put the chart on the statement in the comment.
And Your Honor, just for
And
future,
I'll
I'm sorry.
make a copy for you.
And
Your Honor, I'm hearing
my experience,
someone else, some third party speaking. I don't know if they're talking case or another case.
Yes, it's this case. It's Ms. Cooper from confinement advising me why it was booked that way. Yes, Mr. Linder?
just in my experience for future reference, the capias itself, generally speaking, is accurate as to the specific nature of the offenses.
All right, thank you. So for some reason, these, this was inaccurate. So I need to go through the capias with the actual charges. So count 1 would, I do make a finding of probable cause, lewd and lascivious molestation victim, 16. Yes, Mr. Jaffe.
Interject. When counsel says that he finds that these capias are generally accurate, that does not meet the legal standard. And I would object to that statement. Sorry, counsel, let me finish. I'll give you an opportunity to speak. I would object to the court finding probable cause at this time if the state is going to take the position that these capias are, quote, generally, close quote, accurate. They either have to be accurate or they're not accurate. The law is clear about this.
So the capias I'm finding are accurate. What's inaccurate, Mr. Jaffe, are the findings. The findings make this a PBL where he's non-bondable. So I'm fixing the capias because he is entitled to bond. If you're objecting to me doing that, I can leave it as it currently is.
I am not, Your Honor. Thank you.
All right.
All I was referring, I'm sorry, all I was referring to, Your Honor, the clerk's office creates these capiases, so I can't speak for what the clerk's office does in every case, but I certainly wasn't speaking to the allegations in this case.
All right, guys, we're not going to go back and forth. So I am making a finding on count one, lewd and lascivious molestation, victim less than 16 years old, offender 18 years old or older. He is now bondable on that offense. Count two, lewd and lascivious exhibition. Offender the offender is over 18 on count two, not less than 18, and the victim is less than 16 years old. Count three, lewd and lascivious conduct by a person over 18, not less than 18. As indicated in the capias and the information provided in the probable cause affidavit. So Mr. Linder, hold on, let me mute this first to you.
Judge, I'm recommending a $75,000 bond on each count. Pretrial release of the GPS monitor level 2, no victim contact, no contact with minors. Your Honor, it's based on the allegations in the report. Not only the age of the alleged victim at the time of the incident, but I believe the relationship between the defendant and the victim is an aggravating factor for the court to take into consideration. As far as his history, Your Honor, out of Broward, I'm showing 2004, 2 counts of burglary of a conveyance, 04, burglary conveyance, 03, resisting without violence, 02, 2000, possession of cocaine. One moment, Your Honor. Let's see what the charge is. Your Honor, while I'm not showing the offense, I'm showing in 2000, he had a federal prior, and in 2015, his supervised release was revoked, and he was sentenced to 3 years with the Bureau of Prisons.
Is there a way to find out what that federal prior is?
I will do my best, Your Honor.
All right, thank you. Mr. Jaffe?
Your Honor, we've known about this case. Mr. Striegels came in and retained me several months prior. I was in contact with the detective several months ago. I asked them when they were going to make an arrest to let us know so we could do a voluntary surrender. Of course, they did not. They came to Mr. Striegels' place of residence yesterday and made the arrest. Mr. Striegels is gainfully employed as a long-distance truck driver. He is traveling nationwide. He has been doing that since for months now. He's not a risk of flight. He stays in constant contact with my office. Again, he is a nationwide truck driver. This is historical conduct. This allegation is from a niece. There is no physical evidence that links him to this whatsoever. There's no DNA evidence. There's no audio. There's no video. There's no controlled phone call that was made where Mr. Striegels allegedly made any admissions. This is solely a minor female and her mother making allegations, and what's not listed in this arrest affidavit. And there's a psychic that's involved that's pushing these folks to go forward with this. Mr. Striegels was supporting the mother financially, and when he cut off financial support, that's when these allegations came forward. So clearly, there's some problems with the state's case that are not outlined within the four corners of the arrest affidavit, which we have other issues with. We're asking the court to not issue the GPS monitor or any restrictions on his ability to travel. He is not a risk of flight, clearly. He's been gainfully employed. He travels throughout the United States as a long-distance truck driver. He's not a danger to the community. There's no evidence that these events occurred other than this minor female making these allegations. And there's no independent witnesses to these allegations either. One of the things that the court has to look at is the strength of the state's case. It's a very weak case in terms of a lewd and lascivious charge. It really is. So we're asking the court to set a reasonable bond of $25,000 per count for a total of $75,000 corporate surety bond in this case.
All right, thank you.
Your Honor, while I still cannot see what his federal prior is, I did come across significantly more priors out of the state of Florida. From 2004 out of Martin County, uttering 4 counts of unauthorized use of or possession of a driver's license or identification card, 4 counts of fraudulent use of personal identification information, 6 counts of using a counterfeit payment instrument, fleeing and eluding law enforcement at a high rate of speed or disregard for safety, grand theft, and obstructing a criminal investigation, as well as another grand theft, uttering a forged instrument, another fleeing and eluding law enforcement, and organized fraud under $20,000. He also had a grand theft out of Charlotte County in 2012. On the Martin County cases, he was sentenced to, on the fleeing and eluding, 5-year state prison, 3 years on the remaining charges. On the Charlotte County case, Your Honor, he was sentenced to 1 year and 8 months state prison. Nothing further, Judge.
So, Your Honor, just so I'm correct, a majority of this criminal conduct occurred approximately 7 years ago, and I believe the last criminal conduct occurred approximately 9 years prior. Just want to make that clear.
I believe that federal supervision was revoked in 2015, what the state put on the record.
That would be approximately 7 years ago.
Oh, he was also sentenced to 3 years state prison, Your Honor. So his release from federal prison would have been much more recent than that.
All right, thank you. So on count 1, I am going to set bond in the amount of $50,000. Counts 2 and 3, $25,000 each. Once he posts bond, he's going to be supervised by pretrial release. So after you post your bond, you have to call into pretrial release before 11 a.m. the next business day. Mr. Striegels, please provide your phone number to pretrial so they have it on file.
Your Honor, I would just have,
Do you have it, Mr. Jaffe?
yes, Your Honor, I just have a request of the court that he be allowed to be employed as a long distance truck driver and he be able to continue to travel nationwide as a long distance truck driver.
As long as pretrial, he's on standard pretrial. I don't believe that's a problem, correct, Ms. Brown?
As long as you go
Okay, so for now, he can, does he have to leave Florida, Mr. Jaffe?
Yes, Your Honor, he travels nationwide.
Okay, but he can leave for work purposes only, but it needs to be approved by pretrial. And when he gets back, he has to report to pretrial within the next business day before 11 a.m. every time he comes back.
That's fine, Your Honor. One of the realistic issues with pretrial is to try and get prior approval is sometimes people call, you don't get calls back. Sometimes it takes days, if not a week, if not longer, to get approval. So that's why I'm requesting the court to just grant him his ability to drive nationwide. And I would ask that he be able to take these trips and notify pretrial services in advance. And if he's not able to get in touch with them, that he at least notify them so they know where he is at any given time.
Ms. Brown, is that fine? Can he be allowed to travel for work purposes, but I'm ordering that he needs to advise pretrial when he's coming back so that he can report to pretrial before 11 a.m. the next business day when he comes back. However, you guys are doing the recording now.
Well,
This would be over state's objection, Your Honor. If there is in fact an issue with Mr. Striegels being able to advise pretrial in advance, then that can be brought to his division judge. But to allow him just to travel around the country without even advising pretrial beforehand, because of Mr. Jaffe's representation that you just can't get in touch with pretrial, I think is a bit premature.
No, we're not saying without notifying them. What we're saying is that he be allowed to travel, but in the course of travel, still communicate with pretrial, notify them, let him know before he's going. If they don't communicate back with him, he still be allowed to travel. And while he's traveling, he still communicate with them and try and reach out to them.
So based on these allegations, he needs approval, okay? So he needs approval. If he doesn't get it, he has to set a motion, okay? And please prepare an order to that effect. And he needs to report the next business day before 11 a.m. when he gets back. Sir, please provide your phone number to pretrial so they have it on file.
954-604-8534.
Did you get that? 604-8534.
Yes, ma'am.
All right, sir, you also cannot have any contact with the alleged victim. Initials is ZS as in Zeta and Sierra, Mr. Linder.
Correct, Judge.
Contact with the alleged victim, initials ZS, direct or indirect. Do you understand, sir?
Yes.
That means that you cannot go where she's living, going to school. You cannot call her, text her, email, social media, letters, have a family member or friend send a message to her or any other means of communication that I have not said. Do you understand?
Yes.
You also cannot have any contact with any minors under the age of 18. Do you understand?
Yes.
All right, is there anything else in Mr. Striegels' case that we need to address? Anything, Mr. Jaffe?
No, Your Honor. Thank you so much for the court's patience and time. I really appreciate it.
No problem. Thank you, sir. Take care.
Thank you, Judge. You too. Bye-bye.
All right, take care. So Mr. Ducko was here, but he stepped out. So let's take Ms. Chukwuemeka's case, Mr. Nahomi on page 8, I believe.
Come on up, sir.
Your Honor, good morning. We have stipulated bond amount for counts 1 and 2 with no victim contact, all subject to the court's approval.
Thank you, Ms. Chukwuemeka. What was the agreement of the parties?
7,500 on count 1 and 1,000 on count 2, no contact with the victim.
All right, thank you. Mr. Linder, does he have any priors? All right, thank you. Mr. Nahomi, good morning, sir. I do find probable cause, count 1, domestic battery by strangulation, count 2, touch or strike battery, domestic violence, count 3, misdemeanor capias for failing to register an automobile. I do make that finding. I am going to approve the parties' recommendation as I've been advised that there are no priors. So on count 1, I will set bond in the amount of $7,500 to $1,000, and I'll leave the bond in place on count 3 for the capias. And sir, the conditions of your bond, even while you're in custody, you cannot have any contact, direct or indirect, with the listed victim. Do you understand? I can't hear you.
Yes, ma'am.
All right, sir, thank you. That means that you cannot live with her, call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes, ma'am.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
No.
All right, thank you. Is there anything else in Mr. Nahomi's case that we need to address, Mr. Plummer or Mr. Linder?
No, Judge.
No, Your Honor, have a nice day.
All right, thank you. Have a great day.
Yes.
All right, so next, while we're waiting on Mr. Ducko to get back, let's take Mr.
Your Honor, excuse me, do you still need the Spanish interpreter?
I do, yes, sorry. I will swear you in because I do have a Spanish interpreter case and a private attorney case as well. This next case, where did he go? There he is, Mr. Duran. Mr. Duran's client, Mr. Contreras. So let me swear you in, Mr. Interpreter. Sorry about that. Thank you. Do you swear or affirm to translate from Spanish to English and English to Spanish to the best of your ability?
I do. Esteban Rojas.
All right, thank you, Mr. Rojas. This is on Mr.
Okay.
Contreras on page 8.
Okay.
Do you have the DV no contact orders for these cases? All right, Mr. Contreras, good morning, sir.
Buenos días, señor Contreras.
The court does have
Morning.
probable cause, count 1, operating without a valid driver's license.
Considero que existen indicios probables para el primer cargo, operar un vehículo automotor sin licencia válida.
Count 2, aggravated battery with a deadly weapon, domestic violence.
El segundo cargo, lesiones agravadas con arma mortal en violencia doméstica.
Count 3, battery caused bodily harm, domestic violence.
Tercer cargo, lesiones en calidad de doméstica, de violencia doméstica.
Mr. Linder, first to you, sir.
Señor Linder.
Do you have the DV
Your Honor, I see no history.
The last one.
Señoría, no veo ningún historial.
Sorry, no priors.
I see no history, Your Honor. Based on the level of violence alleged in the report,
Dado el nivel de violencia que se alega en el informe,
Yes, sir.
I'm recommending a $10,000 bond on count 2
voy a recomendar
and a
una fianza de
$1,000 bond on count 3
$10,000
with no victim contact.
para el segundo cargo. Para el tercer cargo, una fianza de $1,000 y que se le prohíba el contacto con la supuesta víctima.
Just noting the level of violence and the injuries suffered by the alleged victim involving potential artery and ligament damage.
Tomando nota simplemente del nivel de violencia y lo que sufrió la supuesta víctima a nivel de daño en sus ligamentos y potencialmente daño arterial.
Thank you, Mr. Duran.
Gracias,
Yes,
señor
Judge,
Durán.
as Mr. Linder stated, he has no priors. He works as a roofer. His family was the one to retain us.
Gracias, señora juez. Como dijo el señor Linder, él no tiene antecedentes, trabaja en los techos, su familia fue la que nos contrató.
Judge, this is a case involving his ex-fiance who they share a child with, as well as her current boyfriend at the time. The incident occurred back in December of 2020.
Su señoría, este incidente tiene que ver con su exnovia, con quien comparte un hijo, y su exnovio de ese momento también. Este es un incidente que ocurrió en diciembre del 2020.
The mother of his child is on. She is under Galaxy S10.
La madre de
Currently
su
unmuted.
hijo sí está aquí, aparece identificada como el Galaxy S10.
I can only hear from people if they have their full legal names listed, Mr. Duran.
Solo puedo escuchar a las personas si tienen identificación con su nombre completo legal, señor Durán.
Rixie, can you please change the name on your Zoom?
Si puede, por favor, cambiar su nombre en Zoom.
Your Honor, so for the past 7 months, they have continued to remain in contact as they do have child sharing and
Su señoría, durante los últimos 7 meses, ellos sí han permanecido en contacto, ellos tienen responsabilidades conjuntas con el hijo o hija.
So, Your Honor, we'd ask for, instead of a $10,000 bond, a $7,500 bond, as well as if Your Honor is going to grant a stay away order against both victims, that there be an exception for the one with the mother of his child so that they'd be allowed to text purely for child care purposes.
Y su señoría, solicitaríamos en lugar de una fianza de $10,000, una fianza de $7,500, y que si va a haber una orden separando a las respectivas víctimas, que haya una excepción para la madre de su hijo o hija para que puedan permanecer en contacto para temas relacionados con la crianza del niño.
All right, thank you, Mr. Duran. Mr. Linder, I don't have any of the names to do a stay away order because
Bien, gracias, señor Durán. Señor Linder, no tengo ninguno de los nombres necesarios para redactar un auto prohibiendo el contacto.
everything is redacted.
No, I have it.
Todo está, ha sido censurado en el acta.
The name of the alleged victims, Your Honor, are first name Rixie, R-I-X-Y.
Los nombres de las supuestas víctimas, su señoría, son primero el nombre Rixie, R-I-X-Y.
Last name Maradiaga, M-A-R-A-D-I-A-G-A.
Apellido Maradiaga, M-A-R-A-D-I-A-G-A.
And the other alleged victim is first name Lester, L-E-S-T-E-R.
La otra supuesta víctima, el primer nombre es Lester, L-E-S-T-R-E-R.
Last name Anton, A-N-T-O-N.
Apellido Anton, A-N-T-O-N.
All right, thank you. Based on these allegations, as well as the allegation that there was alcohol involved,
Dadas las acusaciones, así como la acusación de que hubo alcohol de por medio,
and the allegation that this was allegedly occurred at their child's birthday party in the presence of the child and other witnesses,
y la acusación de que esto supuestamente ocurrió en la fiesta de cumpleaños de un niño en presencia de otros testigos.
I am going to set bond on count 2 at $10,000
Voy a imponer la fianza para el segundo cargo en $10,000,
and on count 3 at $1,000.
para el cargo $3,000.
Once he posts bond, he's going to be supervised by pretrial release.
Una vez que pague la fianza, deberá ser supervisado por el programa de medidas cautelares.
So, sir, please give your phone number to pretrial before I continue with my orders.
Así que, señor, por favor, dele su nombre, su número de teléfono al departamento de pretrial antes de continuar yo con mis órdenes.
954
954
381
381
6543.
6543.
Did you get 381-6543?
381-6543.
Maduro. Sí.
Yes.
All right, sir, you cannot have any, as a condition of your bond and pretrial, you cannot have any contact with either of the listed victims, direct or indirect. Do you understand?
Bien, señor, como condición de sus medidas cautelares, a usted se le prohíbe tener contacto ya sea indirecto o directo con las víctimas, ¿entiende?
Okay.
Ok.
That means no phone calls, no text messages, no emails, no social media.
Eso significa que no puede llamar por teléfono, no puede enviar mensajes de texto, ni por redes sociales, ni correo electrónico.
No letters, no having a family member or friend send a message to either of them.
Ni cartas, ni tampoco enviar mensajes mediante amigos o familiares.
Or having a family member or friend send a message to either of the listed victims or any other means of communication that I have not said.
Ni tampoco que ningún amigo o familiar le envíe un mensaje a cualquiera de las supuestas víctimas, ni tampoco cualquier medio de comunicación que yo no haya mencionado.
Do you understand?
¿Entiende?
Yes.
Yes.
Right now, without hearing from the listed victim, even though she's allegedly on, I am not going to make any exceptions. You'll need to file a motion with his division judge.
Bien, entonces, sin escuchar a la supuesta víctima, no voy a hacer excepciones, pese a que la víctima supuestamente se encuentra aquí, van a tener que presentar una moción ante el juez de la división asignada.
Understood, Your Honor, we will.
Sí, lo haremos, su señoría.
Sir, based on the domestic violence nature, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Con base, dada la situación de violencia doméstica de la que se le acusa durante el periodo de pendencia de este caso, usted no puede poseer ningún arma de fuego, ¿entiende? Okay.
You also cannot use any drugs or alcohol while your case is pending based on these allegations. Do you understand?
Tampoco puede consumir drogas o alcohol durante el periodo que se encuentre pendiente de este caso, ¿entiende? Okay.
And you're going to be randomly screened for drugs and alcohol at least 2 times per week. Understood?
Y mínimo 2 veces por semana a usted se le va a ordenar hacer pruebas sin aviso de drogas y alcohol, ¿entiende? Okay.
And you cannot drive without a valid driver's license based on count 1. Do you understand?
Y no puede, dado el primer cargo, usted no puede conducir sin una licencia válida, ¿entiende? Yes, okay.
All right, sir. Anything else on his case?
Bien, señor, ¿alguna otra cosa?
No, Your Honor.
No, su señoría.
All right, thank you. Take care.
Bien,
Thank you,
gracias,
Judge.
cuídese. Your Honor, do we have a case number or arrest number for Mr. Contreras?
Yes, 822-100026.
Okay, thank you.
Okay, thank you. Let me take Mr. Ducko's case and I'll finish the Spanish interpreter cases for you, okay? Thank you so much, Mr.
All right.
Rojas.
Sure.
All right, welcome back. This is Mr. Foster on page 16. Mr. Ducko is here on his behalf. Just give us 1 minute for him to walk up, Mr. Ducko.
Good morning, Your Honor. Mike Dutko on behalf of Melvin Foster.
All right, good morning, Mr. Ducko. Nice to see you, sir.
Well, thank you. How are you?
All right, is this Melvin Foster here on page 16?
Yeah, Your Honor.
All right, thank you. All right, Mr. Foster, good morning, sir. The court does make a finding of probable cause for murder, dangerous, depraved, without premeditation, count 1, the only count. I also make a finding of proof, evident, presumption, great, but I do so without prejudice. Let me mute this so I can go to Mr. Linder first from the state.
Your Honor, 1 moment.
I can take the stack next. Okay, I'm just gonna start.
Thank you, Your Honor. Judge, at this time, I am recommending that the court hold Mr. Foster no bond so that there could be an Arthur hearing in front of the assigned judge. I do believe that would be an appropriate hearing, considering the allegations in this case, to allow both parties to have an opportunity to provide the court with argument. Judge, excuse me. While I do understand that Mr. Foster advised law enforcement that he saw the victim reaching for something, I would also note that where the victim was ultimately located and in his vehicle, there was no firearm or any type of weapon recovered, Your Honor. There is no indication that Mr. Foster actually saw the victim in possession of a firearm or weapon. Your Honor, it would appear this is a road rage situation, and which ultimately led to the victim's death. So based on that, I'd ask that the court hold a no bond, additional release condition of no firearms, weapons, or ammunition. Nothing further at this time, Judge.
Okay, thank you, Mr. Linder. Mr. Ducko, sir?
Judge, I would point out to the court that this case doesn't necessarily hinge on whether the victim actually had a firearm. What we do know is that once this incident occurred, whatever it was that occurred, Mr. Foster contacted law enforcement, drove to a safe area, waited for law enforcement, and voluntarily surrendered to law enforcement after having called 911. I've been to the house. I've not had an opportunity to interview Mr. Foster yet, but I've seen the house. They own the house. He's a longtime resident of Broward County, got significant ties to the Broward County community, especially to the Caribbean community. I think under the circumstances, it's not unreasonable to ask the court to consider a bond in the neighborhood of, for example, $100,000 with some strict special conditions, and that be whatever the highest level is. I always confuse level 1 and level 2, the highest level of electronic monitor, to permit him to be home so that we can begin to prepare to deal with this case. He's a business owner. His wife works. They have significant ties to the community. He's neither a risk of flight nor danger to the community.
All right, thank you, Mr. Ducko. Mr. Linder, does he have any priors?
No, Judge.
52 with no priors. Okay. I do know that this is an alleged road rage incident. I also know that both the alleged victim, who then subsequently died, and Mr. Foster both called 911. Mr. Foster advising that this was allegedly done in self-defense, as he alleged that the listed victim cut in front of his automobile. And then allegedly the listed victim reached for something. All right, I am going to exercise my discretion, but I'm going to set bond in the amount of $250,000. Once you post a bond, Mr. Foster, you're going to be supervised by pretrial release level 1 with a GPS. That means that you are going to be on strict house arrest, sir. Do you understand?
Sure.
All right, and you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes, sir.
If you still have any in your possession, you need to turn them in by advising pretrial so that they can allow you to leave the house into strict house arrest. You need to turn them into your local law enforcement office within 24 hours of your release. Do you understand?
Yes, sir.
All right, anything else on Mr. Foster's case?
Judge, you didn't address this, but his wife surrendered to me last night a U.S. passport and a Jamaican passport that I've got in my possession. We will hold them at the direction of the court. I will surrender to the clerk if you direct me to.
Okay, so you can either hold it or surrender it. Do you want to prepare an order one way or another, Mr. Linder? Which does the state prefer? Have a preference?
Your Honor, Mr. Deco is an officer of the court. If he's advised that he has received them, and then he's also advised the court that he's going to hold on to them for the pendency of the case, I'm satisfied with that.
Okay, I just need to, I need to that effect that Mr. Ducko is going to hold on to the passport so that we have a trail of it.
Yes, yes, sir.
All right, anything else on Mr. Foster's case? Anything else on Mr. Foster's case?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor. Thank you for your time.
All right, thank you. So how do I word it in the findings then? What do you guys want me to put in the findings, Mr. Linder and Mr. Ducko?
Sorry?
About the passport, what do you want me to put that, his attorney, Mr. Foster's attorney, defendant's attorney shall, hold on to the passport for pendency of the case?
Yeah, I think that's fine. And obviously, if for some reason Mr. Ducko isn't representing him at some point, that could be addressed before the assigned judge for a modification.
And he shall not reapply for one.
Right.
All right, thank you. Thank you, Mr. Ducko.
Thank you, Your Honor.
Nice to see you. All right, so let's do our last two Spanish interpreter cases at Maine, and then we have one at North Broward. So let's go back to page 9. Thank you for your patience, Mr. Rojas.
Sure.
Okay, thank you. Next is Mr. Gutierrez-Rojas on page 9, no relation. All right, Mr. Gutierrez, good morning, sir.
Señor Gutiérrez, buenos días.
Is this Mr. Gutierrez here?
¿Es este el señor? Sí.
Okay, thank you. The court does find probable cause for petty theft, second degree, first offense.
Sí, considero que existen indicios probables para hurto menor. Did you say first offense, Your Honor?
Yes.
Primer delito, primera ofensa.
I know he has no ties in this from Chile, so I'm not sure if the state has any priors or an offer or an objection to an ROR in the alternative.
Sé que no tiene lazos con las comunidades de Chile, así que no sé si la fiscalía tiene alguna objeción a que sea liberado bajo palabra.
Your Honor, I don't know if he has any history. I mean, if he wanted to resolve the offer via withhold, court cost, no return, I suspect Mr. Romero is going to advise his client not to resolve the matter. In that case, Your Honor, considering the circumstances, I'd be fine with an ROR, no return.
No sé si tiene, qué es lo que piensa hacer. Me imagino que el señor Romero le va a aconsejar que no resuelva el caso. Si fuera a resolver el caso, sería simplemente no. Could you repeat the offer, Mr. Linder?
Withholding court cost.
Sería un fallo sin condena y costas judiciales y que se le prohíba regresar al sitio.
Judge, I did speak to him. We're no objection to an ROR. We're going to be asking to be provisionally appointed on his case.
Señora juez, sí, no tenemos ninguna objeción. Solicitamos una liberación bajo palabra. Solicitamos ser designados provisionalmente a su caso.
All right, sir, you are going to be released ROR.
Bien, señor, usted será liberado bajo palabra.
Mr. Romero, do you have his phone number?
Señor Romero, ¿tiene su número de teléfono?
I'm going to get it right now, Judge.
Voy a obtenerlo ya, señor juez.
Are you ready to go on the out of turns with your, you too. Mr. Roberts, are you ready to go on the other out of turns with the other jails? On the other jails? Sanchez? Sure.
Thank you, Judge.
Gracias, señor juez.
All right, so sir, you are going to be released on your own recognizance, but you cannot return to the Sawgrass Mills Mall. Do you understand?
Bien, señor, usted queda liberado bajo palabra, pero no puede regresar al Mall Sawgrass Mills, ¿entiende?
Más alto.
Entiendo.
Yes, I understand.
All right, I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic.
Bien, también voy a designar provisionalmente la Oficina de los Defensores Públicos para representarlo durante el periodo de pandemia.
Once COVID is over, you will need to reapply if this case is still pending. Do you understand?
Una vez que se acabe la pandemia de COVID, tendrá que volver a presentar la solicitud para que lo representen. ¿Entiende?
Sí, entiendo.
Yes, I understand.
All right, anything else on his case?
¿Tiene alguna otra cosa?
Nothing else, Judge.
Nada más, señor juez.
All right, thank you. Next, let's go to Mr. Alvarez,
Gracias.
page 13, the next Spanish interpreter case.
Your Honor, can we get the arrest number for Mr. Gutierrez?
Does somebody have it for him, please? I'm multitasking with all the findings up here.
252 100 349.
Thank you.
All right, thank you, Mr. Alvarez. Good morning, sir.
Gracias, señor Álvarez. Buenos días.
The court does find probable cause for failing to stop or remain in an accident involving non-serious injury.
Considero que existen indicios probables por el delito de no detenerse durante un accidente que no involucra lesiones severas.
Although I will note the probable cause indicates the victim was trauma alerted with a head injury to the hospital.
Aunque sí debo tomar nota de que la víctima fue, se le señaló posible trauma y fue transportada al hospital con una lesión en su cabeza.
That being said, Mr. Linder, first to the state.
Pero sin embargo, señor Linder, primero escucho a la fiscalía.
Your Honor, I'm recommending a $15,000 bond, pretrial release supervision with an order of no driving until further order of the court.
Su señoría, voy a solicitar una fianza de $15,000, medidas cautelares y que se le ordene no conducir hasta que se disponga lo contrario.
Thank you, Mr. Romero.
Your Honor, there was more
Romero.
information. I just
Oh,
want
sorry.
It's okay.
Hay más
Sorry, Leonard.
información,
Sorry.
su señoría.
Your Honor, he does have a 2007 leaving the scene of an accident.
Su señoría sí tiene un antecedente de abandonar la escena de un accidente en el 2007.
And while it is dated, he had a DUI in 1994.
Y si bien es antiguo, tuvo un DUI en 1994.
Your Honor, while I certainly acknowledge Mr. Alvarez's age.
Y su señoría sí tomó nota de la edad del señor Álvarez.
I do have concerns based on the allegations that you've already placed on the record, Your Honor.
Pero tengo preocupaciones dado lo que se ha señalado en el acta.
Nothing further.
Nada más.
My apologies. Thank you, Mr. Romero.
Gracias, señor Romero.
As you heard, Mr. Alvarez has limited contact with the criminal justice system.
Gracias, señora juez. El señor Álvarez tiene el contacto limitado con el sistema judicial penal.
He's been residing here for the past 40 years.
Tiene 40 años de vivir acá.
He gets Social Security.
Recibe Social Security.
He lives here in Hollywood. He's been living at the same premises for a number of years.
Vive en Hollywood. Ha estado viviendo en el mismo sitio durante varios años.
Now, he does have family that reside here in Broward County.
Ahora sí tiene familiares que viven acá en el condado de Broward.
Specifically, I believe his son is the person that's going to be helping to post his monetary bond.
Específicamente creo que es su hijo quien va a ayudar a pagar la fianza.
At this time, we're going to be requesting the court consider setting a $5,000 bond and provisionally appointing my office.
En este momento vamos a solicitar que su señoría imponga una fianza de $5,000 y que designe provisionalmente a mi oficina para representarlo.
Thank you, Mr. Linder. Is there an update on the alleged victim's condition?
Gracias, señor Linder. ¿Hay alguna actualización sobre la supuesta víctima, la condición en la cual se encuentra?
No, Your Honor. Unfortunately, the only information I have is what is contained in the probable cause affidavit.
No se señoría, lamentablemente la única información que tengo es lo que está en el affidavit sobre indicios probables de delito.
All right, thank you.
Bien, gracias.
All right, I am going to set bond in the amount of $10,000, and I am deeming Mr. Alvarez a flight risk based on these allegations.
Bien, voy a imponer una fianza de $10,000 y considero que el señor Álvarez representa un riesgo de fuga dadas las acusaciones.
Noting the strength of the state's case where there were multiple witnesses, there was video evidence.
Dada la fortaleza de los argumentos presentados por la fiscalía, en donde hay evidencia por video y hubo múltiples testigos.
As well as an alleged confession to police where he admitted to hitting the alleged victim, a pedestrian, while he was coming back from the Hard Rock Casino.
Así como una supuesta confesión por parte del señor Álvarez, en donde supuestamente dijo que reconoció haber golpeado a la víctima, un peatón, cuando se encontraba regresando del Hard Rock Casino.
All of this allegedly at 2:53 in the morning.
Todo lo cual ocurrió supuestamente a las 2:53 de la mañana.
Sir, once you post bond, you're going to be supervised by standard pretrial release.
Señor, una vez que pague su fianza, usted se deberá someter a las medidas de rigor cautelares.
Please provide your phone number to pretrial.
Por favor, dele su número de teléfono a la oficina de medidas cautelares pretrial.
Sí, 954
Yes, 954
990
990
99
9914.
14.
Did you get that, Ms. Brown? 9914, yes. Welcome. All right, sir, the conditions of your bond and release are that you cannot have any contact, direct or indirect, with a listed victim. Do you
Bien,
understand?
señor, como consecuencia de su fianza y de su liberación, usted no puede tener contacto ni directo ni indirecto con la supuesta víctima, ¿entiende?
Entiendo.
Yes, I understand.
That means no phone calls, text messages, emails, social media, letters.
Eso significa que no puede no puede comunicarse con la supuesta víctima ni por teléfono, ni por redes sociales, ni correos electrónicos, ni cartas.
Having a family member or friend send a message to the listed victim or any other means of communication that I have not said.
Ni tampoco instar a familiares o amigos a que se comunique con la víctima, ni tampoco utilizar ningún otro medio de comunicación que yo lo haya mencionado.
Do you understand?
¿Entiende?
Entiendo.
Yes, I understand.
You also cannot drive while this case is pending. Do you understand?
Tampoco puede conducir mientras se encuentre pendiente este caso, ¿entiende?
Entiendo.
Yes, I understand.
And I apologize, Mr. Romero, does your office need to be provisionally appointed?
Disculpe, señor Romero, ¿necesita ser designada provisionalmente su despacho para representarlo?
Yes, Judge.
Sí, su señoría.
Thank you.
Gracias.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir.
Voy a designar provisionalmente a la Oficina de Defensores Públicos para representarlo durante la pandemia, señor.
Once COVID is over, you will need to reapply to make sure they keep representing you.
Una vez que se acabe el COVID o la pandemia de COVID, deberá volver a presentar la solicitud para que los defensores públicos lo representen.
Thank you. Anything else on his case?
Gracias. ¿Alguna otra cosa?
Anything else, Judge?
Nada más, señor juez.
Good luck to you, sir.
Buena suerte, señor. Can we get the arrest number, Your Honor?
I can give it to you. It
Okay.
is 552-107-467.
Okay, thank you.
Thank you. So let's go to North Broward. They do have one Spanish interpreter case.
Sanchez on page 14.
Okay, thank you. This is Mr. Sanchez on page 14. Good morning, sir.
Señor Sánchez, buenos días, señor.
The court does find probable cause for your capias for trespassing,
Considero que existen indicios probables para su orden de detención por entrar ilegalmente en una propiedad,
as well as your capias for retail theft that you're being held no bond on, that I have no discretion over.
así como su orden de arresto por hurto en un establecimiento. Yo no tengo ninguna discreción sobre ese tema, no hay fianza posible.
Mr. Linder, does the state have an offer on count one that you can convey to Mr. Weathers so they can go to a breakout room?
Señor Linder, la fiscalía tiene una oferta para el primer cargo que pudiera ser transmitida al señor Weathers para que los ponga en una sala aparte de Zoom.
On count one, it would be a withhold core cost, no return to the Hard Rock Hotel and Casino.
Para el primer cargo sería fallo sin condena a costas judiciales y se le prohibiría regresar al Hard Rock Hotel y Casino.
Okay, so I will send you back all to the breakout room and I will see you all in a little bit if you don't mind, Mr. Rojas.
No problem, Your Honor.
Okay, thank you. So I'll see you all in a little bit.
Nos vemos en breve. Voy a ponernos una sala aparte de Zoom.
Okay, and we do have one Creole interpreter case and she happens to be on page one. Good morning, ma'am. Thank you for joining us.
Good morning, Your Honor.
All right, let me swear you in. From Creole to English and English to Creole to the best of your ability.
I do, Your Honor. For the record, Martin Moline Pellissier, certified Haitian Creole court interpreter.
All right, thank you. This is on Miss Charleston on page one.
OK, ça c'est sous Miss Charleston dans page 1.
Good morning, ma'am. The court does find probable cause for touch or strike, a battery, domestic violence.
Bonjour, Madame Charleston, tribunal agent que gen cause probable pour moyen ou soit frappé, coup ak blessure, violence domestique.
Mr. Linder, first to you, sir.
Monsieur Lender, n'attendons en premier, monsieur.
Judge, I'm recommending $1,000 bond, no victim contact. Ms. Charleston was arrested for domestic violence battery against the same alleged victim in 2019, and that was dropped.
Juge m'a recommandé $1,000 et pas en contact avec victime non. Miss Charleston a été arrêtée pour violence domestique grave en 2019 et il a été quitté qu'à tomber.
Thank you, Mr. Romero.
Merci, Monsieur Romero.
Judge, no objection. $1,000 bond is what we were going to ask for. I'm going to be asking to be provisionally appointed on Ms. Charleston's behalf.
Pas d'objection, juge. $1,000, c'est ça nous t'avons demandé et nous avons demandé tout pour le juge la nommer nous provisoirement comme avocat pendant la pandémie.
All right, ma'am, I am going to set your bond in the amount of $1,000.
Madame, pral mette caution là à $1,000.
The conditions of your bond, even while you're in custody, are that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Condition cautionnant, c'est que pour pas avoir aucun contact ni direct ni indirect avec victime supposée, même là où en détention. Vous comprenez? Est-ce que vous comprenez?
Speak up. A little bit
Allez,
louder.
puis. Yes.
That means that not only can you not live with him, you cannot call him, text him, email, social media.
Ça veut dire non seulement pas capable de vivre avec mon nom, ou pas capable de brûler dans le téléphone, ou pas capable de envoyer message par texte, ou pas capable de envoyer email, ou pas capable d'aller dans les médias sociaux.
Have a family member or friend send a message to him or anything else any other means of communication that I have not said.
Ou bien faire une famille, ou bien un ami, envoyer un message bali, ou bien utiliser aucun autre moyen de communication que je n'ai pas mentionné là.
Also, based on the domestic violence nature, ma'am, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Et puis tout, basé sur le fait que c'est une violence domestique, ou pas gain droit posséder ni armes à feu, ni armes, ni munitions pendant que Kawa li en attente. Est-ce que vous comprenez ça?
Oui.
Yes.
And I will provisionally appoint the office of the public defender to represent you during the pandemic.
Et puis, on va le nommer provisoirement bureau défense publique là pour représenter pendant que Kawa li en attente.
Once COVID is over, you will need to reapply to make sure that they keep representing you.
Après pandémie en fini, ou à obligé de réappliquer pour capable continuer à représenter. Est-ce que vous comprenez ça?
Anything else in her case that we need to address?
Est-ce qu'on a l'autre bagaille pour nous adresser et au sujet de cas madame ça?
No, Judge.
Non, juge.
All right, thank you. Good luck to you, ma'am.
OK, merci. Bonne chance, madame.
Okay, so we have to wait on Mr. Weather. Thank you, Madam Interpreter. Do you need the case number?
I have the case number. I don't have the first name, Your Honor.
Charlene, Charline.
Thank you, Your Honor.
All right, thank you. Have a good day.
Thank you. Likewise.
All right, so let's see, Mr. Weather stepped outside, so we have to stick with main jail. When he gets back, we'll handle the Spanish interpreter cases and the out of turns. Who's the first person at main we can do is Fountain then on page 3, correct, Mr. Romero?
That is correct, Judge, and I am Ms. Fountain's appearance.
Okay, thank you. I do find probable cause for her out of county hold from St. Lucie County. She's being held, no bond is going to be transported there. Anything else in Ms. Fountain's case?
No, Judge.
Okay, thank you. So next at main jail, who do we have there? Is it Miss Ram Hussain?
That is
correct. Sorry about that. All right, ma'am, good morning. She's on page 5. I do find probable cause, use, display, or possession of firearm during a felony, count 1. Count 2, possession with intent to sell or deliver cannabis. Count 3, possession with intent to sell or deliver THC. Count 4, possession with intent to sell or deliver alprazolam or Xanax. Count 5, possession with intent to sell or deliver LSD. Count 6, possession with intent to sell or deliver amphetamine or Adderall. Mr. Linder, first to you, sir. Hold on, let me mute. Okay, first to you.
One moment.
Ram Roop Singh.
Page 5.
We're going to go back to the Spanish interpreter when you're done, and then the out of turns at the other jails.
Judge, may I inquire?
There's no history. I'm recommending an ROR count 1, asking that the court keep the bonds in place on 2 through 6. It would appear that Ms. Ram Singh, based on the evidence and her statements made to law enforcement, is actively engaged in drug dealing, Your Honor.
Okay, thank you. Mr. Romero, sir.
Judge, before I proceed, I just wanted to inquire if Mr. Weathers had any PC objection regarding Ms. Ram Roopson.
Could you say it one more time?
Do you have any PC objections before he proceeds?
I have a no PC objections, but just as far as to the nature and circumstance to the use of and display of the firearm during the felony. It's not that, although Mr. Linder had noted that she's involved in the drug dealing, but during the incident at the home, nothing was used as far as to make sure that her drug deal goes forward okay, or that it is successful. The firearm was in her bag. It wasn't, the officer never saw her actually use it during that incident. As far as the case law is concerned as to use or display, I did not note that whether or not the officer had to see it used or displayed during the incident. And that's an argument for nature of the circumstance, but as the PC, I would leave that in the court's discretion.
All right, thank you so much. So I maintain my finding. Mr. Romero, to you.
If I heard correctly, I know Mr. Linder's recommendation was ROR, I believe in count 1, leave the remainder bonds intact. If that's the recommendation, no objection. I'm going to be asking to be provisionally appointed on her case.
Thank you. So I am going to release you on your own recognizance on count 1, ma'am. On counts 2 through 6, I will leave the bonds in place, but a condition of your bonds and your release conditions, ma'am, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? Was that a yes?
She answered in the affirmative.
All right, thank you. I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply to make sure that they keep representing you, okay? Anything else on her case that we need to address?
No, Judge.
All right, thank you. Good luck to you. Next, let's go back to Mr. Sanchez on page 14, so that Mr. Rojas has been patiently with us this morning. All right, so Mr. Weather, you have an opportunity to speak to Mr. Sanchez regarding the state's offer.
Yes, Your Honor. He's going to plead no contest.
Sí, su señoría, el señor Sánchez declara que no se opone al cargo.
It's Barbero. All right, sir, please raise your right hand for me to the best of your ability. You're next.
Señor, levante su mano derecha, por favor.
Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Jura o firma solemnemente decir la verdad, toda la verdad y nada más que la verdad.
Yes.
Yes.
Thank you. You can put your hand down.
Gracias. Puede bajar la mano.
And please state your name for the record.
Diga su nombre para el acta, por favor.
Bárbaro Sánchez.
Bárbaro Sánchez.
Mr. Sanchez, it's my understanding that you wish to accept the state's offer for your trespass case, correct?
Señor Sánchez, tengo entendido que usted desea aceptar la oferta de la Fiscalía para el caso de entrada ilegal en una propiedad. ¿Es así?
Sí.
Yes.
And do you understand the charge against you?
¿Entiende los cargos en su contra?
Sí.
Yes.
Do you understand everything that's happened here today?
¿Entiende todo lo que ha sucedido aquí hoy?
Sí.
Yes.
Is anyone forcing you to resolve this case?
¿Alguna persona lo está obligando a resolver este caso?
No.
No.
Do you need more time to speak to your attorney?
¿Necesita más tiempo para hablar con su abogado?
No.
No.
Do you understand you have a right to go to trial and to fight this trespass charge, but you're giving up that right forever by accepting this plea?
Usted entiende que tenía derecho a ir a juicio y combatir este cargo de entrar ilegalmente en una propiedad, pero está renunciando permanentemente a ese derecho al aceptar esta oferta.
Yes.
Yes.
Have you ever been treated for a mental or emotional illness, sir?
¿Alguna vez ha sido tratado por una enfermedad mental o emocional?
No.
No.
I'm not asking if you're a United States citizen. I just have to advise everybody that comes before me on a plea
Y yo no le estoy preguntando si usted es ciudadano de los Estados Unidos o no, pero tengo que informar a todas las personas que vengan ante mí por una negociación como esta.
You understand that if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
Usted entiende que si usted no fuera ciudadano de los Estados Unidos, el declararse con respecto a este delito podría exponerlo a ser deportado.
Sí, entiendo.
Yes, I understand.
And how do you wish to plead, sir? Guilty or no contest?
¿Cómo se declara, señor? ¿Culpable o no lo disputo? ¿O no me opongo?
Culpable.
Guilty.
All right, sir, I accept your guilty plea is freely, voluntarily, and knowingly given. I will sentence you to
Bien, señor, acepto su declaratoria de culpabilidad. Considero que se ha presentado de manera libre, voluntaria y con conocimiento de causa. Se le impone la siguiente sentencia.
withhold of adjudication and court costs with an order of no return to the Hard Rock.
Fallo sin condena y costas judiciales y se le ordena no regresar al Hard Rock.
I also find that there's a factual basis for your plea based on the probable cause affidavits.
También considero que existe base fáctica para su declaratoria con base en los hechos que constan en el affidavit sobre indicios probables de delito.
And how much time does he need to pay, Mr. Weathers, or are you asking for?
¿Cuánto tiempo necesita él para pagar, señor Weathers, o ya se le preguntó?
1 year.
1 año, su señoría.
All right, sir, I will give you 1 year to pay the court costs.
Bien, señor, le voy a dar 1 año de tiempo para pagar las costas judiciales.
Good luck to you, Mr. Sanchez.
Buena suerte para usted, señor Sánchez.
I will provisionally appoint the Public Defender's Office to represent you on count 2.
Voy a designar provisionalmente al despacho de defensores públicos para representarlo para el segundo cargo.
Once COVID is over, you'll need to reapply if that case is still pending, okay?
Y una vez que se acabe el COVID, usted tendrá que volver a solicitar que lo representen cuando se acabe la pandemia, ¿entiende?
Sí.
Yes.
All right, take care, sir. You have to go to Judge Casey to address that no bond hold.
Bien, cuídese, señor. Tiene que, el juez asignado de su división es el juez Casey. Para el otro caso donde no tiene fianza.
Thank you, Mr. Rojas. Have a great day for your patience.
Pleasure, Your Honor.
¿Por qué el otro caso?
He's asking, what other case?
The no bond on the 21598 CF10A, it's a grand theft.
21598 CF10A. Para ese caso, usted está siendo acusado de hurto mayor.
¿De dónde?
Where?
I've appointed a public defender to represent you, Mr. Sanchez. Please contact them so that they can go into the specifics of the allegations with you, okay?
Te ha asignado un defensor público para que lo represente, señor Sánchez. Por favor, hable con esa persona para que le explique los particulares de ese caso.
Good luck to you, sir.
Gracias. Buena suerte, señor.
All right, thank you again, Mr. Rojas.
Pleasure.
All right, so let's go to Paul Ryan. Let's take Ms. Plow out of turn on page 6.
Judge, I'm going to step away for a moment, okay?
No problem. Thank you so much. All right, so good morning, ma'am. This is a change of charge. It's a technical change of charge, Mr. Weathers. I'm not sure if you saw the PC findings versus what was actually charged. It's still a burg dwelling.
Yes. I did, Your Honor.
All right, thank you. So, Ms. Plow, good morning, ma'am. I do find probable cause for the burglary of a dwelling. And so at the original magistrate hearing on 5/8, the weekend magistrate judge set bond in the amount of $3,500 with a no victim contact and a no return order. Any legal objection from either of the parties to reinstating those conditions as that previously?
No, Judge.
Yes, Judge. As to the $3,500 amount,
What's the legal objection?
to the bond amount, Your Honor.
What's the legal objection? I'm waiting.
Oh, well, she does, because if she's in a financial crisis, Judge.
That's not a legal objection, Mr. Weathers. That's a request. So it's a separate question. Do you have a legal objection?
As to your finding for the probable cause, or are you talking about us for the bond, Your Honor?
For the bond, Mr. Weathers, I need a legal objection if you have a legal basis why I cannot impose the bond that was originally set by the weekend magistrate.
Judge, if the court is going to maintain the $3,500 amount for what the weekend magistrate had found, I don't have a statute or a case law as to why I brought that in. It's just that she's in a financial crisis as it relates to the bond amount, so.
All right, not a problem. So there's no legal objection, but you are making a request.
Yeah, yes, Judge, I am making a request of the court.
Your Honor, I can also advise the court that she's being held on 2 other counts with $5,000 bonds each on drug dealing charges. But there's a Nebia hold. She's got to see her judge before she can get out anyway. So I just asked that the court keep the original bond in place.
Okay, if that's then I don't have an objection, Judge. I agree with what the prosecutor just said.
All right, thank you. So Ms. Plow, Mr. Linder, Mr. Weathers, thank you all for that. So Ms. Plow, I am going to reinstate your bond at $3,500. You'll have to see your division judge for relief. I'm not going to change what the previous magistrate originally said. The conditions of your bond remain in place, Ms. Plow. That means that you cannot return to the listed victim's home. Do you understand?
Yes.
Is that a yes?
Yes. Yes.
You also cannot have any contact, direct or indirect, with the listed victim, even while you're in custody, ma'am. Do you understand? Is that a yes?
Yes.
All right, thank you. Anything else on her case that we need to address?
No, Judge.
All right, thank you, ma'am. Good luck to you. Let's go to the second look at Paul Ryan. That's Miss Shive. All right, ma'am. Good morning.
Good morning.
All right, so let me go to Mr. Linder first. Let me mute myself. This is a driving under the influence and driving under the influence with property damage or injury that she's being held on a $200 bond plus pretrial service. It's rather low. Okay.
Yes, Your Honor. I didn't see any history. While I normally, obviously, I wouldn't, have recommended $100 bond be set, especially on a crash case. The fact remains that the first appearance judge set the bonds at 100, and because considering that's the amount that appears to be standing in between her getting released and staying in custody, I'd be fine with the court at this point just RORing her to pretrial. It does say in the findings no alcohol or intoxicants. It doesn't specifically say random testing, so in abundance of caution, Your Honor, I'd ask that you include that condition as well.
Let me the police reports because I don't know if I agree with that.
Okay.
So it looks like it's alleged that she collided with another automobile. Let me see what the damage or injury were. It doesn't indicate. I'm looking at it on I'm able to access CMS. They fixed that for me. Thank you. Okay, she has no priors?
I didn't see anything, Your Honor.
What's her date of birth? Just a minute. She's 14. Okay. So, all right. So I'm willing to release her to pretrial release, but with the stipulation, she's going to be randomly screened at least 2 times per week based on these allegations that not only was there a crash, but she allegedly offered the officers sexual favors to let her go. So she's going to have to randomly screen 2 times per week.
Judge, for pretrial services, could she have her show up to pretrial because she does not have a phone currently at the moment?
I think you guys are still doing phone, right? Yeah. It's still phone for now. She can call from a friend, family member's phone. It doesn't have to be her phone if she doesn't have one.
Okay, that was her current concern. All right, thank you, Judge.
All right, no problem. So Ms. Shive, I am going to release you to pretrial release. You cannot use any drugs or alcohol while your case is pending, but you're going to be randomly screened at least 2 times per week while your case is pending. Do you understand?
Yes, ma'am.
All right, you have to call in tomorrow morning before, hold on, I'm going to mute you, Mr. Weathers. I'll unmute you. Sorry, there's an echo. Have to call, you cannot use any drugs or alcohol while your case is pending, and you have to call in tomorrow before 11 a.m. Although I've been advised you don't have your own phone right now, just when you call in a pretrial, give them a phone number and an address where they can find you with a family member or friend, okay?
Yes, ma'am.
All right, anything else on her case?
Where do I call into?
They gave you the phone
Okay,
number, it's
sorry,
right in your
I
hand,
got the
ma'am.
information.
All right, good luck to you. Oh, we need
ma'am.
the random screens 2 times. I'll do it. All right. All right, thank you. Next, at Conti facility, if you guys are still there, let's take Ms. Crumb on page 12. Mr. Apologies, sir. All right, it's Mr. Crumb. My apologies. All right, Mr. Crumb, good morning.
Morning, Your Honor.
I do find probable cause for petty theft, second degree, but third or subsequent offense. Mr. Linder, to you first.
Just asking the court to keep the bond in place with an order of no return. Mr. Crumb is being held on the first charge, no bond on a violation of pretrial.
Okay, thank you. Mr. Weathers, anything to add other than a provisional appointment?
No, Your Honor.
All right, thank you. All right, Mr. Crum, I am going to leave the bond in place because you still have to see your division judge with regards to that no bond hold, but you cannot return to the lows if your division judge releases you from custody. Do you understand?
Yes, Your Honor.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure that they keep representing you. Good luck to you, sir.
Thank you, ma'am.
Thank you.
All right, so let's start on page 1 then. I had Jean pulled for some reason. I think that was a mistake. Okay. All right, so on page 1, the listed victim is outside, so just give them a minute. Miss Osman, just give them a minute, ma'am. Good morning. They're gonna pull him in.
No problem, Your Honor.
All right, thank you. Miss Osman, good morning.
Good morning.
All right, good morning, ma'am. The court does find probable cause for touch or strike battery, domestic violence. Just give me 1 minute because the listed victim is here. All right, sir, good morning. You are the listed victim, correct? Or ma'am, my apologies. Ma'am. All right, ma'am, and please, are you here to say something to me, or did you just want to see what happens?
No, I'm not here to say anything.
I can't hear you.
I'm not here to say anything.
Okay, thank you for being here, Miss Did she say something else? Did I?
No.
Okay, all right, so thank you for being here. Let me mute this, Mr. Linder, first to you.
Thank you, Judge. I see no history. I'm recommending an ROR to pretrial and no victim contact, Your Honor.
All right, thank you. Mr. Weather, sir?
No objection, Judge. Just as to the no victim contact, does Usme reside with victim?
I'm not sure.
Nothing. I just got an answer, Judge. So thank you. So yeah, nothing further.
Does your office need to be provisionally appointed?
Yes, Judge. May my office be provisionally appointed to Usme's case.
All right, not a problem. Okay, Ms. Osme, I am going to release you to pretrial release. That means that you're going to get out today, but you have to call into pretrial release before 11 a.m. tomorrow. So please provide your phone number to pretrial before I continue with my orders. Oh, sorry, you guys need to unmute her.
9. Oh, I say the number?
Oh, no, no, it's okay. It's for the defendant. You guys have to unmute her.
All right, it is 786.
786,
508 6147.
Did you get that, Ms. Brown? No, I didn't get that. Okay, one more time, please.
786 508 6147.
6147.
6147.
Yep. All right, ma'am. Thank you. You cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
That means that you cannot live with her. You cannot call her, text her, email, social media, or have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes.
You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply to make sure that they keep representing you. Anything else on Mr. Osme's case that we need to address?
No, Judge.
Anything from the victim? Okay, thank you for being here, ma'am. All right, good luck to you, ma'am, and good luck to you, Ms. Osme.
Thank you.
Call in tomorrow before 11. All right, so that brings us to page 2, Ms. Cole.
No problem, Donna.
Ms. Cole, good morning, ma'am. The court does find probable cause for trespassing. Mr. Linder, does the state have an offer if she wishes to resolve?
Yes, Your Honor, one moment. Offers withhold court costs, no return.
Thank you. Mr. Weathers?
Yes, she accepts a no contest plea.
Yes, Ms. Brown? Okay, so yes, Ms. Brown, please proceed.
Judge, Ms. Cole is being supervised by pretrial on case number 21003293MO10A for intoxicating beverages. And we're asking for that supervision to be revoked due to the new arrest.
All right, at this time, I'm going to take no action. It's a municipal ordinance. Pretrial can file a motion with her division judge, okay? But with regards to this new law, Ms. Cole, please raise your right hand for me if you wish to resolve this trespass. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth? Sorry, is that a yes?
Yes, ma'am.
All right, thank you. There was an echo. I couldn't hear. My apologies. You can put your hand, state your name for the record.
Carrie Lee Cole.
All right, Ms. Cole, it's my understanding you wish to resolve this trespass case, correct?
Yes, ma'am.
And do you understand the charge against you?
Yes, ma'am.
And do you understand everything that's happened here today?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Do you understand that you have a right to go to trial, but you're forever giving that up by accepting the state's offer?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
And I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen, that taking this plea today shall subject you to deportation proceedings?
Yes, ma'am.
And how do you wish to plea, ma'am? Guilty or no contest?
No contest.
All right, ma'am, I accept your no contest plea is freely, voluntarily, knowingly given. I find there's a factual basis for this plea based on the probable cause affidavits. I am going to sentence you to a withhold of adjudication plus court costs. Mr. Weathers, how much time does she need to pay?
And I'm going to ask for a civil lien.
All right, not a problem. I'll also order you to not return to the incident location, and I'll convert your court cost of prosecution, PD application fee to a civil lien, Ms. Cole. What that means is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay this off, Ms. Cole. Good luck to you. If nothing else is holding you, you should be released today. Good luck to you, ma'am.
Thank you.
No problem. That's on page 2.
No problem, Donna.
All right, thank you. Ms. Velez, good morning, ma'am. The court does find probable cause for a KPS for petty theft. Mr. Linder, does the state have an offer if she wishes to resolve?
Yes, one moment, Judge. The offer would be a withhold court cost, no return to the Lowe's at 3651 Turtle Creek Drive in Coral Springs.
Okay, thank you, Mr. Weathers. What does she wish to do?
Your Honor, I'd have to discuss the offer with her just for a moment.
Okay, no problem. We'll put you on a brief recall so you can speak to your attorney, Ms. Velez, to let us know what you want to do today, okay? All right, so she's on a brief recall. Let's go to the next, we can't go to the next. So let's go to the next person at Maine. Who's that? Let's see, Mr. Dean, on page 7, correct? I believe it's correct, Mr. Romero?
Me?
All right, thank you. Mr. Dean, good morning. Court does find probable cause, Tetra strike battery, domestic violence. Mr. Linder, first to you, sir.
Recommending $1,000 bond, no victim contact. This is based on injuries suffered by the alleged victim. Also, Mr. Jean was arrested for simple battery in 2017 against a different alleged victim, and the case was dropped. Nothing further.
Okay, thank you, Mr. Romero.
Judge, no objection. We're going to be asking to be provisionally appointed.
All right, thank you. Okay, Mr. Jean, I am going to set your bond in the amount of $1,000, sir. The conditions of your bond, even while you're in custody, are that you cannot have any contact with the listed victim, direct or indirect. Do you understand?
That's all.
That means that you cannot live with her, call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand? All right, you also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? Sorry, I couldn't hear him.
That's it.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you, okay?
That's all.
Anything else on this case that we need to address?
No, Judge.
All right, thank you. Good luck to you, sir. All right, are you ready on Ms. Velez?
Yes, Your Honor.
All right, thank you. So let's go back to Ms. Velez. All right, Ms. Velez, good morning. Okay, so what does she want to do?
She's going to plead no contest, Judge.
All right, thank you, ma'am. So please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down and please state your name for the record.
Melody Velez.
All right, Ms. Velez, it's my understanding that you wish to resolve your trespass case, correct?
Yes, ma'am.
Sorry, petty theft case.
Yes.
All right, just so we're clear, we're all on the same page. Mr. Linder, what number petty theft would this be?
This will be a first, Your Honor.
All right, thank you. So I just need to know that. So now that we're on the same page, do you understand the charge against you?
Yes.
All right, and do you understand everything that's happened here today?
Yes, ma'am.
All right, is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of alcohol or drugs today?
No, ma'am.
And do you need more time to speak to your attorney?
No, ma'am.
Do you understand you have a right to go to trial, but you're forever giving that up by accepting the state's offer of a withhold of adjudication and court costs?
Yes, ma'am.
All right, and have you ever been treated for a mental or emotional illness?
No, ma'am.
And I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. If you're not a United States citizen, do you understand that taking a plea today shall subject you to deportation proceedings?
Yes, ma'am.
I also must advise you that upon a third arrest after 2 convictions for a petty theft, it may result in you being charged with a felony and receiving jail or prison time. Do you understand?
Yes, ma'am.
And knowing all that, how do you wish to plead? Guilty or no contest?
No contest.
All right, Ms. Velez, I accept your no contest plea is freely, voluntarily, knowingly given. I find there's a factual basis for your plea based on the probable cause affidavit, and I'll sentence you to a withhold of adjudication, court costs, plus a no return to the incident location put on the record by the state. Mr. Weathers, how much time does she need to pay?
1 year, Your Honor.
All right, no problem. All right, Ms. Velez, I will defer your court costs, cost of prosecution, PD application for 1 year. Good luck to you, Ms. Velez. If nothing else is holding you, you should be released today, ma'am.
Thank you.
Of course, take care. All right, next is Ms. Jimenez on page 3, also at North Broward. A lot of people at North Broward today. All right, Ms. Jimenez, good morning, ma'am.
Good morning.
The court does find probable cause counts 1 through 6, grand theft over $750, less than $5,000. Count 7, burglary, unoccupied structure, unarmed. Count 8, grand theft, less than $750, of over $5,000. Mr. Linder, first to you.
Judge, I'm asking that the court keep the bonds in place on all the grand thefts. These are filed charges. I'm asking that Your Honor set a bond $3,500 on the burglary with an order of no return. It would appear, Your Honor, that all of these incidents occurred while she was out on 2 pending grand thefts, 2 separate grand thefts from 2019.
And they're still pending?
Yes, Your Honor.
Any priors? Okay, thank you. Mr. Weathers?
Yes, Judge. The nature of the circumstance for these facts are they're related to baby formula and baby products to take care of her children. Currently, right now, Your Honor, she has 3 kids. She is a single mom. She is involved in government housing. She has fell victim or in many cases, or in some instances, of the complainant to burglary of her own home, where the landlord had to put up shelter and repair the government housing that she was in because she has to pass inspection under the federal government and the state government. Currently, Your Honor, she works at Rivera Country Club. She just runs various errands for them on that property. It's a very insignificant amount of income that she receives. She herself has overcome a substance abuse issue. She did enter a program through DCF. She's been clean now for just over a year, Judge. She does not receive any help from her husband or her significant other. In order to take care of the children, her mother also helps. So therefore, Your Honor, as to the $1,000 count, that's a $1,000 amount for each count with the exception of the burglary, which is at $3,500. Your Honor, I'd ask for $500 on counts 1 through 6 and count 8. And as to count 7, Your Honor, I'd ask for a $1,500 amount.
Your Honor, I have her history, but I would also note it does not appear that this was a situation where she was just stealing breast formula for her children. There are 2 instances where she stole the same exact breast pump from 2 different locations. So clearly it would indicate she wouldn't need 2 of them. There's also at least 2 of the allegations are that she was stealing vacuums. Your Honor, I'm showing at a Dade County. She has a drug paraphernalia she put out this year. 2017 grand theft. 2017 grand theft. 2017 grand theft. 2016 petty theft. 2016 grand theft. Also showing out of the state of California, 2010 petty theft. Nothing further, Judge.
All right, thank you. I do know that the allegations are not that she was stealing items from children, but allegedly multiple breast pumps, as well as vacuum cleaners, multiple vacuum cleaners, a Nest thermostat, and alleged 2 Dyson vacuums were allegedly stolen during the burglary. Nothing to do with the items for her children, allegedly. So I am bond on count 7 at $3,500 while she was out on bond for 2 pending grand thefts with those numerous grand theft convictions. She's alleged to have committed all of these cases. Leave the bonds in place with an order of no return to all of the incident locations. Ma'am, I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you'll need to reapply to make sure that they keep presenting you. Good luck to you, Ms. Jimenez. Next is Ms. on page. That brings us to page 7, Mr. Simpson.
He's approaching, Judge. You're at me.
Okay, thank you.
Judge, just to refresh your recollection, Mr. Simpson advised me he had private counsel, Sasha Francis.
Thank you. Mr. Simpson, good morning, sir. Did you or your family actually pay or retain an attorney to represent you this morning?
As far as I know, there should be.
Okay, what's that name again, Mr. Romero? Sasha.
I believe Francis.
Okay, thank you. They're not here right now, so let me look on the Florida bar to see.
You said Sasha, right? First name? Sasha.
Let me look on the Florida bar.
Okay, Sasha. Where's Sasha with the Z? You know.
Okay, I see a person by that name on the Florida bar, but they're not here right now. So, Mr. Linder, if I give you or this phone number for her, can one of you please step outside and call her and let her know she needs to log in?
Sure.
Okay, thank you. Okay, so it's right here. I'll leave it on the bench for you all so you can give her a call. We're going to put you on a brief recall and see if she wishes to join us, okay?
Thank you, Judge.
All right, thank you. So he's on a brief recall. Okay, so next is Mr. Wadhavania, who's a medical reset.
Correct, Judge.
Okay, thank you. Next is Mr. Randy Rivera on page 8.
Right next to me, Judge.
All right, thank you, Mr. Rivera. Good morning. The court does find probable cause for domestic battery by strangulation. Let me mute this. Mr. Linder, first to you.
Recommending a $7,500 bond on victim contact based on the level of violence. Noting Mr. Rivera was arrested in 2014 for a simple battery against a different alleged victim, and that was dropped. Nothing further.
Okay, thank you. Mr. Romero?
Judge, as you heard, I believe Mr. Rivera is a complete record. He did advise me he's a registered voter in our community. He's been here for the past 10 years. He works for Spirit Airlines. He's a flight attendant there. He did advise me he makes approximately $27,000 annually. Now, he does live with the alleged victim. I did advise him as far as the significance of the no contact order. He does have a cousin that he could reside with at West Park that he could turn to. Judge, based on his strong ties, his limited contact, I'm going to be asking for a $3,500 bond on Mr. Rivera's behalf, Judge.
All right, thank you. Based on these allegations that he was allegedly grabbing the victim's phone with one hand, trying to grab the phone while she was calling for help allegedly, and her throat with the other hand, it's a possibility the state could also file tampering charges, but I am taking that into consideration when setting the bond. I am going to set bond as requested by the state in the amount of $7,500 based on the allegations I put forth on the record. The conditions of your bond, Mr. Rivera, even while you are in custody, are that you cannot have any contact, direct or indirect, with the listed victim. Do you understand, sir? Is that a yes?
Yes. He answered in the affirmative, Judge.
All right, thank you, sir. That means that not only can you not live with her, you cannot call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means that I have not said. Do you understand?
I understand.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand? Is that a yes?
Yes.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure that they keep representing you. Anything else on his case?
Enough, Judge.
All right, thank you. Good luck to you. All right, next is Mr. Slaughter on page 9.
He's approaching, Judge, in Maine.
All right, thank you. Mr. Slaughter, good morning, sir.
How you doing?
I'm fine, thanks for asking. I do find probable cause for this case for operating without a valid driver's license. Mr. Linder, when you get an opportunity, do you have an offer for him if he wishes to resolve this 2016 operating without?
Hold on. Your Honor, if I could just have one moment, I'm on the phone, Ms. Francis. I'm just getting her email address and send her the Zoom link.
Okay,
And Judge, for the court certification.
just give us 1 minute, Mr. Slaughter. Thank you.
And Mr. Slaughter does wish to resolve, Judge.
Sign these while I'm waiting.
Sorry about that, Judge. Who are we on?
This is on Mr. Slaughter
Slaughter?
on page 9. Does the state have an
Yeah.
offer?
Offer be a withholding court cost.
Okay,
Judge.
thank you. And Mr. Romero, what does your client wish to do?
He wishes to accept the state's offer in exchange for his no contest plea.
All right, thank you, sir. Please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
No.
All right, thank you. You can put your hand down and please state your name for the record. All right, Mr. Slaughter, it's my understanding you wish to resolve this case, correct?
Correct.
Do you understand the charge against you?
Yes, I do.
Do you understand everything that's happened here today?
No.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of alcohol or drugs?
No.
Do you need more time to speak with your attorney? And do you understand that you're forever giving up your right to challenge this case and take it to trial by accepting of the state's offer?
Yes, sir.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
Okay.
All right, sir. And how do you wish to plead? Guilty or no contest?
No contest.
All right, sir, accept your no contest plea is freely, voluntarily, knowingly given. I'll sentence you to withhold of adjudication and court costs. And how much time does he need to pay?
1 year, Judge.
All right, not a problem. I'll give you 1 year to pay your court costs, cost of prosecution, PD application fee. Mr. Slaughter, good luck to you, sir. If nothing else is holding you, you should be released today.
Thank you.
All right, take care. On this one, I had to add no firearms, weapons, or ammo because it was TV and no victim contact wasn't checked. Okay, thanks. All right, so next is Mr. We did that one. Did we do Mr. Jones?
Mr. Jones is right next to me, Judge.
Where's Mr. Randall? I have him here, but that's not the correct page. Okay, Mr. Jones. All right, sir. Good morning, Mr. Jones. I do find probable cause. Count 1, driving under the influence of alcohol or drugs, first offense. Count 2, driving under the influence with damage to person or property of another. Count 3, leaving the scene of an accident or crash involving damage to property. I do note he's not from here. It's alleged that he is from Georgia and has no ties. Mr. Linder, first to you.
Yes, Your Honor, and because of that, I'm asking that the court keep the bonds on 1 and 2 in place, but additionally, based on the nature of the charge, set a $500 bond on count 3. Should he post bond, pretrial release, and testing? Nothing. 1 moment, Your Honor, and I am also showing history out of Florida. 2020, resisting without violence. 2015, strong arm robbery and escape. 57.5 months state prison as a habitual offender. 2015, possession of methamphetamine, same sentence. 2014, grand theft and resisting without violence with a VOP, same sentence. 2013, grand theft, VOP, same sentence. Nothing further.
Thank you, Mr. Romero.
Judge, that is correct. Mr. Jones, visiting. My understanding, he intends on going back in about a couple of weeks. He is visiting friends. Judge, what we were going to be asking is, I know he has priors, but I believe nothing recent. Considering he does not live in our community, we were going to be asking the court to consider a straight bond. $1,500 bond is currently what it's at. I know in speaking to Mr. Jones, he's looking forward to fighting this and having his day in court. My understanding, Judge, I believe he was submitted to field sobriety tests, in which, according to Mr. Jones, he passed. I know the court found probable cause, Judge, but he is looking forward to having in court. I'm asking at this time for the court to leave the standard bond in place and to provisionally appoint my office, Judge.
All right, thank you. So with regards to the field sobriety exercises, it's alleged that he lacked smooth pursuit in both eyes with the horizontal gaze nystagmus test, displayed nystagmus at the point of maximum deviation, and also displayed nystagmus at approximately 30 degrees prior to the point of maximum deviation. So that's, he didn't pass that. The next exercise he was asked to perform was a balance test. It's alleged he was not able to keep his eyes closed and noticeably swayed back and forth from side to side. He was also asked to keep his eyes closed for 22 seconds as opposed to the 30 seconds he was instructed to do so. And so it means he didn't pass that. And then he was asked to perform the finger to nose exercise. The deputy or the officer in this case, because it is Hard Rock, so it's a Seminole Police Department, had to explain the instructions to the defendant 2 different times. And then he was not able to follow the instructions that were given to him at first. He would then bring his hand towards his nose, touch the bridge of his nose, and then brought his arm forward. He would also begin to perform the exercise before being instructed to do so. Finally, he was not able to keep his head tilted back and open his eyes several times, plus notably swayed in a circular motion. The last exercise he was given was a walk and turn exercise. He was instructed to take 9 steps forward and walk heel to toe on each step. It's alleged he did not walk heel to toe on for 4 of the 10 steps that he took. The exercise was given on a flat surface in the parking garage. So it sounds like he failed each and every field sobriety exercise. I know what he advised you of, but the police report reads differently. So I am going to leave the bonds in place on 1 and 2. On 3, I'll leave it as NC, but once you post bond, sir, you're going to be supervised by pretrial release, meaning you'll have to call into pretrial release the next business day before 11 a.m. So please give your phone number to pretrial before I continue with my orders.
My phone number is 305-417-2511.
All right, hold on. Miss Brown, did you get that? One more time, but a little louder.
305-417-2511. And
all right, we got it. All right, so sir, you cannot use any drugs or alcohol while your case is pending because you are going to be randomly screened for drugs and alcohol. You also cannot return to the Hard Rock Casino or hotel. Do you understand?
That's cool. I'm cool with that, Miss. Your Honor, I'm working hard. I'm order select. I work in Pennsylvania, so that pretrial is gonna hold me back. And you can just look on facts on camera. I walk in straight line.
Do not talk about the facts.
And when they showed me the light, I was looking back and forth. I could have really drove home, honestly.
Talk about the
Don't talk
facts.
about the facts of your case, Mr. Jones. Everything you're saying is being recorded and can be used against you at a later date. Do you understand?
I'm talking facts. I appreciate you.
Constitutional right to remain silent. Your lawyers already advised you to do so. Don't talk about the facts of your case, okay? Do you understand that you cannot go back to the Hard Rock Casino or Hotel?
I do, I understand. I'll take it.
All right, I've also been advised the booking report advises me you live in Georgia, correct? Is that correct? It's Georgia?
He stay in Georgia, but I stay in Pennsylvania. I got a home. That's where I work at. So
Pennsylvania is where he's going to be returning to, Judge.
Okay, so that's why I needed to know because the booking report said Georgia, so I need to change the findings to Pennsylvania. So you're asking for him to reside in Pennsylvania then?
That is correct, Judge.
All right, so I will put in here in the order, Mr. Jones, that you can reside in Pennsylvania so that there's no issue with you going home while your case is pending. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, sir, you'll need to reapply to make sure that they keep representing you. Good luck to you, Mr. Jones. Be in touch with your attorney, sir. It's just random, the standard. He can still do it up there. He's obligated to do it. All right, let's go back to Mr. Simpson. I saw his attorney, Ms. Francis, logged in.
Mr. Simpson, come on up. Attorney.
All right, Ms. Francis, thank you for joining us. Did you have an opportunity to read the police reports provided by Mr. Linder from the state?
Your Honor, I can't provide it. I can't pull it from the packet. I would need it to get scanned to me.
Oh, okay, so hold on 1 minute. Ms. Cooper, can you please do me a favor? Can you please scan Mr. Simpson's booking report, PC, and send it to Mr. Linder so you can send it to Ms. Francis? Thank you. Okay, so Ms. Francis, Mr. Linder, my apologies. Mr. Simpson, my apologies as well. We're gonna have to put you back on another recall. We have to scan the paperwork to your lawyer so that she can get them because otherwise we can't send the entire packet for confidentiality reasons, okay? So just take a seat. We'll come back to you, okay? We need your attorney to read the allegations to know what's happening.
Mr. Randall, you should be next.
All right, so next, what page were we on? Mr. Randall, he's on page 11. That's what happened. It has 9 on here.
That is correct, Judge.
All right, Mr. Randall, good morning, sir. All right, I do find probable cause for your capias for a trespass. Mr. Linder, do you have an offer if he wishes to resolve?
Yes, Judge. Adjudication, time served, court costs no return to Parkside Commons Apartments at 951 Northwest 8th Avenue in Pompano Beach.
All right, thank you, Mr. Linder. Mr. Romero?
Judge, first, thank you for resetting this. I know yesterday he wasn't feeling well. Now he's feeling a little bit better, but he does wish to accept the state's offer in exchange for his no contest plea.
All right, thank you. Mr. Randall, please raise your right hand for me to the best of your ability, sir. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Nice and loud.
Yes.
All right, thank you. You can put your hand down and state your name for the record. Your name, sir?
Randall.
All right, sir. My apologies, Mr. Randall, for butchering your name. I did my best. Do you wish to resolve your trespass case today?
Yes.
All right, and do you understand the charge against you?
Yes.
And do you understand everything that's happened here today?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of alcohol or drugs today, sir? Sorry, was that a no?
No.
All right, and do you understand you have a right to fight this charge and go to trial, but you're forever giving that up by accepting the state's offer?
Yes.
And have you ever been treated for a mental or emotional illness, sir?
No.
I'm not asking you if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you are not a United States citizen that by taking a plea today, it shall subject you to deportation proceedings?
Yes.
And how do you wish to plead, sir? Guilty or no contest?
No contest.
All right, sir, accept your no contest plea is freely, voluntarily, and knowingly given. I do also find there's a factual basis to accept this plea based on the probable cause affidavit. I'll sentence you to an adjudication, time served, and order of no return. And how much time does he need to pay, Mr. Romero?
Judge, I'm going to be requesting a civil lien.
All right, and I'll convert your court cost of prosecution, and PD application fee to a civil lien. What that means, Mr. Randall, is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you would need to pay that off, okay? Good luck to you, sir. If nothing else is holding you, you should be released today. All right, next on page 12 is Mr. Marcelin, who's waived his presence.
That is correct, Judge.
All right, thank you. I do find probable cause for his out-of-county holds. There are 2 of them from Palm Beach County. He's being held no bond and he'll be transported there. Anything else on that case?
Nothing else, Judge.
All right, thank you. Next is Mr. Where's Crumb? Where's Crumb? Oh, we did it. Okay, never mind. We did that already. Next is Mr. Dickey on page 12.
Judge, he's here. We addressed him yesterday on
Yes.
and you released him pre-trial. I think there's an ad charge, count 3.
Yes. So there is an ad charge. I see. I do find probable cause for possession of controlled substance without a prescription. Mr. Linder, any objection to putting this case on pretrial as well with the same random screens?
No, Judge.
All right, thank you. So Mr. Romero?
Judge, no objection, Judge.
All right, so Mr. Dickey, you're also going to be released a pretrial release on this case or this ad charge along with the other cases that I released you to pretrial release yesterday. So you need to call in the pretrial release before 11 a.m. tomorrow. You still cannot use any drugs. You still cannot use any alcohol because they're going to be randomly screened for both. Ms. Brown, I know he gave his phone number yesterday, but do you want it today? All right, so good luck to you, Mr. Dickey. You should be released today and call in tomorrow before 11, okay? All right, so next is Mr. Clark is a delete from our docket because he only had a pretrial warrant. He'll have to go before his division judge to address that. Okay, so next should be Mr. Oh, so what do you want me to write on the findings? Anything or just Ms. Cooper for Clark? Do you want me to write anything on the docket? Yeah. So I'll just write delete on docket on the findings. Okay, so I have to write on here delete from docket. Okay, so that's on Mr. Clark. Okay, so next is Mr.
Ramirez-Ruiz?
Yes, okay, here he is. Yes, it's only on count 7. That was the confusion. Okay, so next is Mr. Ramirez-Ruiz on count 7 only, so I have to cross off everything else. He's also waived his presence, so just give me 1 minute. I have to cross off all these other counts. Okay, so I do find probable cause for his immigration hold. He's being held no bond on that. He'll have to, I'm not going to appoint your office based on the kind of hold. Anything else on his case that we need to address?
Nothing else, Judge.
All right, thank you. Next is Mr. Cangiani on page 13, who's also waived his presence.
That is correct, Judge.
All right, thank you. I do find probable cause for his 2 out-of-county holds from Duval County. He's being held no bond. He's going to have to be transported there to address those holds. Anything else on his case?
No, Judge.
All right, thank you. Next on page 15 is Mr. Smith.
He's approaching Judge here at Maine.
All right, thank you, Mr. Smith. Good morning. I do find probable cause for robbery by sudden snatching without a firearm or weapon, count 1. Count 2, petty theft, 2nd degree, first offense. Let me mute this, Mr. Linder. Any priors in the state's recommendation?
Judge, I'm recommending a $1,500 bond on count 1, no victim contact, no return. I'm showing in no particular order.
Judge, no objection.
Needs a bond also. It says G.
I'm fine with an ROR, Your Honor.
Judge, no objection.
Does he have priors?
His priors are dated, Your Honor.
Oh, okay.
And yeah, it looks like it's misdemeanors. The only felony I saw was from 2001. It was a drug possession, Your Honor.
Okay, thank you. Anything else?
No, Your Honor.
Okay, thanks. I didn't want to interrupt again.
No. I might have misheard. I think Mr. Romero said he did not have an objection.
Oh, I didn't hear. Okay, thank you, Mr. Romero.
I was saying no objection, but just asking to be provisionally appointed.
All right, not a problem. All right, Mr. Smith, I am going to set your bond on count 1 at $1,500. On count 2, I will set your bond. I will ROR you on that count. The conditions of your bond and your release, sir, are that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
That means that not only can you not live with her, you cannot call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes.
Sir, you also cannot return to the incident location. Do you understand? Is that a yes?
Yeah.
Okay, and based on the domestic violence nature, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. Good luck to you, Mr. Smith.
Thank you, Judge.
All right, no problem. Next is Mr. Lewis on page 15, who's waived his presence.
That is correct, Judge.
All right, thank you. I do find probable cause for possession of cocaine, drug paraphernalia, and a pretrial warrant. He's being held no bond on. Based on that no bond hold, I am going to leave the $1,000 bond in place, and I will provisionally appoint your office to represent him during the pandemic. Anything else on Mr. Lewis's case?
Nothing else, Judge.
All right, thank you. Next is Mr. Velez.
He's here on my left.
All right, thank you. Good morning, sir. I do find probable cause for a violation of a risk protection order. Mr. Linder, first to you.
Your Honor, I'm recommending a $15,000 bond, pretrial release of the GPS monitor, level 1, no firearms, weapons, or ammunition. I am greatly concerned based on the allegation that Mr. Velez violated the risk protection order by attempting to purchase another firearm. If the system in place didn't work, he would have gotten his hands on another firearm. Your Honor, I can advise you, I was just reviewing the petition for the active RPO. The law enforcement was initially advised by his mother that he was involved in a physical altercation with his brother. He had become extremely belligerent, began talking to himself as though he was hearing voices in his head. She's advised that he's become extremely paranoid for the past year, thinking that everyone he encounters is trying to harm him. She did advise law enforcement that she was afraid that he would kill her eventually. One moment. While law enforcement was at the scene and conducted a pat down of Mr. Velez, they found 17 throwing knives on his person. When he was questioned about the incident, he looked up in the sky and stated he was seeing elephants and giraffes. They spoke with his brother, who advised that Mr. Velez had become very aggressive with him and his mother over the past year, that he feels unsafe with Mr. Velez in the home and fears that he could possibly kill him and his mother. He stated that Mr. Velez has a small collection of firearms in the backyard of the house and that he sleeps with his firearms. The mother allowed the deputies to check the home for weapons. They did locate a fully loaded Smith & Wesson assault rifle and a fully loaded HI point pistol. There were also several bottles of alcohol that were open, cup filled with alcohol next to the computer where he was sitting. It would appear he was drinking an excess amount of alcohol, which raised additional concerns considering his behavior. Law enforcement also located 2 BB guns as well as 9mm ammunition. He was at that point considered to be a threat to himself and others, and he was transported to Memorial Regional and turned over to medical staff. At this point in time, I don't see any history, Your Honor, but if I do see any before the end of the hearing, I'll advise the court.
Thank you. Mr. Romero.
Judge, Mr. Velez has been residing in our community his whole entire life. He is employed, has been working with the same company for the past 3 years in customer service in Chewy's, where he's making approximately $16 an hour. Now, he does live with his mother in West Park. My understanding, Judge, is I just heard the state from appointed Mr. Velez confirm this is he basically has a clean record. Unfortunately, at this time, he has no one to call to help post his monetary bond. He's not in a position to post his own monetary bond. The only person that can help post his monetary bond is his mother. I don't know how, if she'll be reluctant or she will be willing to even post his bond, but at this time he has no one to help post his bond. Judge, we're asking to be provisionally appointed on his case, and we're asking for a mental health screening on his behalf.
Okay, I will sign that mental health screen. It looks like the final order for the final RPO was issued on January 19th of 2000. Actually, it was on January 6, 2021, that the division judge made findings for a final risk protection order after a hearing based on the allegations. The court finding that he did pose a self to himself and others, and he's in direct violation of this court order by attempting to purchase a firearm, and made a confession that he knew that there was an active RPO against him. I do have significant concerns for the community based on not only the allegations of mental illness, but the allegations of substance abuse as well, and alcohol abuse that combined with the mental health concerns and the direct violation of the court order. I am going to set bond in the amount of $15,000. Once he posts bond, he's going to be supervised by pretrial release level 1 with a GPS. And he's going to be randomly screened for drugs and alcohol at least 1 time per week. And sir, you cannot use any drugs and you cannot use any alcohol while your case is pending. Do you understand?
He answered in the affirmative.
Okay, you also cannot possess any firearms, weapons, or ammunition, and that includes knives and that includes BB guns. Do you understand?
He answered in the affirmative.
Okay, thank you. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure that they keep representing you. And the no possession, Mr. Velez, means you cannot go out and purchase it or find it or get it from somebody else, sir. Good luck to you. All right, next is Mr. Bray on page 16, who's waived his presence. Thank you. I do find probable cause for his violation of parole. He's going to be held no bond for an aggravated battery. Anything else on Mr. Bray's case?
No, Judge.
No, Judge.
All right, thank you. Next is Mr. Brown on page 16.
Is that me?
All right, thank you, Mr. Brown. Good morning. I find probable cause for grand theft over $750, less than $5,000. Mr. Linder, first to you.
Recommending R order pretrial no return.
All right, thank you. Mr. Oh, sorry, I have to unmute. Mr. Romero, sorry, I couldn't hear.
One moment, Judge. Let me ask.
Do you have that piece of paper that I gave you with the phone number? Because I think there was a case on the back.
Judge, at this time, he wishes to accept being released on pretrial.
All right, thank you. All right, sir, so I am going to release you to pretrial release. That means that you're going to get out today, but you have to call into pretrial release before tomorrow. Does your office need to be appointed?
Yes, Judge.
All right, thank you. Please provide your phone number to pretrial, sir, before I continue with my orders.
954
Was that 7?
954. Excuse me, I just got a new phone.
You're okay.
I have a new phone number. 561-829-3416.
Did you get that, Ms. Brown? All right, thank you. All right, sir, you're going to be released today, but you cannot return to the Home Depot. Do you understand?
Allowed.
Yes, ma'am.
All right, I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Brown. Once COVID is over, sir, you'll need to reapply to make sure they keep representing you, okay? Good luck to you. All
Good luck, sir.
Thank you, ma'am.
right, no problem. Ms. Francis, good morning again. Are you ready to go on Mr. Simpson's case? Did you have an opportunity to review the report?
I have, Your Honor, and am ready.
All right, thank you. So let's recall Mr. Simpson on page 7. All right, Mr. Simpson, good morning, sir. I do find probable cause for touch or strike battery, domestic violence. Ms. Brown, first to you, ma'am, from pretrial.
Judge, Mr. Simpson is being supervised by pretrial on case number 21003359MM10A for possession of firearm, ammunition, domestic violence, and suspended driver's license first offense. Due to the new arrest, we're asking for his supervision in that case to be revoked.
I don't understand the charge.
It's,
Is it in violation of a DV order?
Your Honor, if I may,
Please.
there was an injunction order of protection issued. One of the conditions is he's not to be in possession of any firearms, weapons, or ammunition. There's an allegation that he was in possession of a firearm in violation of the conditions of the order of protection.
Your Honor, if
I
I,
didn't even say here, there's no pretrial order in the system.
I did see when I checked the case in VSO Picks, it did say he was ROR. Oh, Your Honor, if you have to go to the felony case, it was downfiled from a felony to a misdemeanor.
Okay, what's the felony case number, please?
One moment.
Your Honor, if I may.
4337 CF10A.
Okay, thank you. Mr. Linder, first to you, and then I'll go to Ms. Francis.
Your Honor, at this time, I would be asking that the court grant pretrial's request, and even though this is a misdemeanor, I would ask that he be held in a bond. My concern is there appears to be a pattern developing. Another woman had to go to a civil judge and seek an order of protection because of allegations of violence by Mr. Simpson. That was granted. He was ordered. He was given an order with several conditions. Not only did he violate one of those conditions, but one of the most significant conditions he violated by being in possession of a firearm. Appeared before the court, got pretrial. Now he's back with another allegation of violence against a different woman, Your Honor. So I do have safety concerns with respect to Mr. Simpson. On the new case before the court, I'd be recommending a $3,500 bond and no victim contact. Nothing further, Judge.
Okay, thank you. Ms. Francis?
Yes, Your Honor. With all due respect to Mr. Linder, he's gotten the facts completely wrong. The case, there isn't a pattern in behavior. The cases are completely separate. The existing injunction was granted on default. It was established to the court that the allegations within that claim was false. There is a motion that is pending before the court to vacate that injunction. Mr. Simpson does not have the gun in his possession. That was a gun that was assigned by his employer. It's owned by his employer. And so he didn't willfully violate the court order. He was, at work at the time of this issue as far as the arrest for running the stop sign. And, and so there's no pattern of violence. This particular issue is separate from the issues that were pending before the court in the civil matter. These particular issues, there's a lot more to it without going into the facts of this particular case that the court will later see. And so we're asking for this, that he be released on bond because there isn't a pattern. Mr. Simpson has had no issues with law enforcement his entire life. There, not even as much as a traffic ticket. He's had no encounter. He has no history of violence. And so I do understand the allegations that were made in the police report. I have seen the entire video of the Ring camera. And there are a lot of things that were missing from there as far as statements and allegations. And so we're asking for this court to grant bond.
Okay, what bond amount are you requesting on the new law, Ms. Francis?
$500, Your Honor.
All right, thank you. I find it aggravating that 2 of their children were present in the car seats when this alleged domestic violence occurred in front of the children at the daycare center while the listed victim was dropping their children off, and he was present with them while she was unbuckling the children from their car seats, it indicates. So I find the state's request to be more than reasonable. I am going to set bond on the new law at $3,500. And also it's alleged that once they got back to the home that these alleged DV continued, where he's then on the ring allegations again, seen pulling her clothing, cornering her, and allegedly yelling at her before locking her out of the home. All of this while he has the other pending case on 21-3359 MM10A. I am going to grant pretrial's request. He's going to be held no bond on that. In regards to the new law, sir, you cannot have any contact, direct or indirect, with the listed victim, even while you are in custody. Do you understand?
Understand.
That means no phone calls, no letters, no having a family member, friend, or associate send a message to her, or any other means of communication that I have not said. Do you understand?
Understand.
And you also cannot possess any firearms, weapons, or ammunition while your case is pending, best based on the domestic violence nature, sir. Do you understand?
Understood.
All right, and Ms. Francis is representing you. So is there anything else on his case that we need to address?
No, Judge.
All right, thank you for being here, Ms. Francis, and logging on so expeditiously. Take care, ma'am.
Okay, thank you. Bye-bye.
All right, so we left off on page 16, Mr. Stadler.
Come on up, Mr. Stadler. He's here, Judge.
Okay, yes, hold on. Ms. Cooper stated she has some information on him.
Judge, on count 1 and 2, even though the state did not file on 1 and 2 for the cases that were on pretrial, we have updated it for no information, and he is now bonded on count 3.
Okay, so state has filed no informations on counts 1 and 2. So those no bond holds should now be ROR. So I'll just do no C for counts 1 and 2. Thank you. And on count 3, I will find PC for the grand theft auto. So Mr. Linder, first to you, sir.
One moment, Judge. Judge, I'm fine with an ROR to pretrial and no return.
Okay, thank you. Mr. Romero, sir.
Judge, no objection. This is what we wanted to see happen. And Mr. Stadler is prepared to give his phone number at this time.
All right.
Pardon me.
Sure.
954-945-0034.
Did you get that, Ms. Brown?
I didn't get the last digit.
Last 4 digits, please.
0034.
0034. All right, sir, you cannot return to the incident location, Greico Chevrolet. Do you understand?
Yes, Your Honor.
You're going to be released a pretrial release, which means you'll get out tomorrow, but you have to call in before 11 a.m. tomorrow. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Stadler. Once COVID is over, sir, you'll need to reapply to make sure they keep representing you. Anything else on his case that we need to address?
No, Judge.
Good luck to you, sir.
Thank you, Your Honor.
No problem, sir. Next is Mr. Krum on page 17.
Judge, I have information for Mr. Crumb.
Okay, hold on 1 second. She has information. Yes, Ms. Cooper?
I'm gonna give you this copy. We need to add the case number. It's the same as count 1. They left it off, so it created a separate case number. There's a corrected odyssey form and a corrected booking sheet.
So do you want me to give it to the clerk then?
Yes, ma'am. And put
Okay.
that case number.
So this, I'll attach it to these. Okay, I'll just paper clip it. Okay, so I was advised by Ms. Cooper that I need to add the case number. It's the same case number to the findings. It's 20-002493 CF10A. So it's going to be the same case number. I just have to handwrite it in here. Good luck to anyone trying to read my handwriting. I'm doing my best. All right, so count 1, I do find probable cause grand theft over $750, less than $5,000. Although noting the reports indicate it's over $20,000 in charges. Count 2, defrauding an innkeeper for $300 or more. Mr. Linder, I also note he has no ties and is from Texas. First to you.
Just to advise the court, again, this is another issue. Count 1 was actually filed as grand theft between $10,000 and $20,000.
That's what I thought it should have been, but okay. So
Yeah.
2493. Okay, go ahead. I'll make that finding if that's what the information says. Go ahead.
Yeah, it is.
Okay.
Your Honor, I'm asking that the court set the bond at $20,000 on each count. No return. I think that is reasonable and fair considering the alleged amount of charges that he ran up at the Atlantic Hotel and Spa and then took off, Your Honor, considering the allegations in the, one moment, Judge, in the probable cause affidavit, without an appropriate bond, I have no confidence of Mr. Crumb's return to this jurisdiction on these charges. He's using a false name, Your Honor, fleeing from the jurisdiction. The other information that's advised what he's done in other jurisdictions, Your Honor. I can advise you that he does have a history out of the state of California. I'm showing a 2018 possession of bad checks and grand theft that is still showing is open, Your Honor, out of the state of Nevada, 2018. Possession of ID or identification information for a false statement. It appears that's still pending out of the state of Texas, Your Honor. Impersonating a public servant, peace officer.
What year?
Yeah, I'm getting that right now, Judge.
All right, and
It
is it
looks
still
like
pending or is that resolved?
that was from 2020, Your Honor. He was just convicted on that June 17th of 2021. It looks like when they arrested him on that, that's when they saw these warrants, and that's what was holding him, and what led to him ultimately being extradited here from the state of Texas, Your Honor. So that's an additional cause for concern, that it took him committing allegedly another offense involving theft-related crime of deception to finally get a hold of him for the local charges.
And I believe he was extradited.
He was from the state of Texas, Judge.
Okay, thank you. Mr. Romero, to you, sir.
Judge, there's no way Mr. Krum is going to be able to afford to post a monetary bond that the state has suggested. My understanding in speaking to Mr. Krum, he was extradited here. He's been in custody now for the past 10 months. He has no money. Judge, these are not both nonviolent. He is going to be coming back here to face these allegations. Pursuant to his request, Judge, he's asking at this time for the court to consider a straight ROR. If the court's not inclined to a straight ROR, then we're asking to leave the standard bond in place.
All right, thank you. I am not going to consider a straight ROR because of the pending offenses of a similar nature. I will increase the bond on count one, but I'm not going to do it to the extent that the state has requested, but it's still going to be increased to $10,000. On count two, I'll leave it in place at $1,000. You cannot return to the Atlantic Hotel, sir. Do you understand?
Yes, ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID's over, you'll need to reapply. I'm deeming him a flight risk based on these allegations. And does he need permission to live in Texas, Mr. Romero? Does he intend on staying here?
No, he intends on going back to Texas, Judge, but coming back here to when his court dates are.
All right, so I'll put in the order that he can reside in Texas, so there's no confusion when he tries to board or plane or however he intends on getting there. Anything else on Mr. Klum's case?
No.
No, I just did standard, I just did bonds. No problem. So 10,000, 1,000, no return. All right, good luck to you, sir. All right, next is Mr. Jones on page 18, who's a medical reset. Next on page 18 is Mr. Waller.
Here at Maine, Judge.
All right, thank you. Mr. Waller, good morning. I do find probable cause, count one, burglary of a conveyance, the dwelling or structure armed. I also make a finding of proof evident presumption great, but I do so without prejudice. Count two should be grand theft of a firearm. Any objection from the parties?
No, Judge.
No, Judge.
All right, thank you. And counts 3 and 4 are possession of weapon or ammunition by a convicted felon. Mr. Linder, first to you, sir.
Judge, I'm asking that the court hold Mr. Waller no bond on count one, just noting the strength of the evidence. There's video surveillance of him committing the offense, sworn testimony from, I believe this is aunt, that identified him, and his own admission, Your Honor, of committing the offense. I'd be recommending a $5,000 bond on count 3, $1,000 bond on count 4. The priors mentioned in the report, I am able to confirm them. We had a 2011 burglary of an occupied dwelling out of St. Lucie County with a petty theft. He was sentenced to 3-year state prison. Also another burglary dwelling, 2011, a year and 9 months state prison. One moment, Judge.
Okay, thank you.
Judge, we do have a request as to finding for the bond amount.
Okay, go ahead, Mr. Weathers.
Yes, Mr. Linder is correct that this actually involved his sister, and the sister was visiting him in Georgia. So they are physically separated, Your Honor. When the sister asked for the firearm back, he did return the firearm to her. Your Honor, because this is a familial relationship, I just asked the court to consider that for bond purposes and make a finding as to this request. Thank you for allowing us to be heard, and Mr. Romero can take the floor now.
Okay, thank you, Mr. Weathers. Mr. Romero?
Judge, I understand the court found proof evident presumption great. Basically, at this time, Mr. Waller has asked me to request of the court for the court to exercise its discretion and impose a monetary bond on count one. My understanding, Mr. Waller has been residing in South Florida for his whole entire life. His work involves interior designing. He lives in Oakland Park with his parents. Both of his parents know that he is in custody. Judge, we are going to first be asking to be provisionally appointed. We're going to be asking for a mental health screening. However, on count one, we were going to be asking for the court to impose a $10,000 bond with level 2 pretrial. And on counts 3 and 4, we were going to be asking on count 3 for a $2,000 bond. No objection with the $1,000 bond requested by the state on count 4, Judge.
All right, thank you. Given the strength of the state's case, the allegations in the report, the video, the alleged confession, as well as the victim's willingness to prosecute, I am going to hold him no bond at this time. He'll have to file a motion for hearing before his division judge. Sir, you cannot have any contact with the listed victim, although you both are related. You cannot call her, text her, email, social media, have a family member or friend send a message to her, or any direct or indirect contact. Do you understand?
Yes, ma'am.
Sir, you need to turn your camera off. You're laying down in bed. These are official court proceedings, and you're interrupting my proceedings by laying down in bed, Mr. Dalis. I'm going to reject you from these proceedings if you do it again. I apologize, Mr. Waller. That's what happens when people don't listen. All right, sir, I will also order that you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes, ma'am.
And I will sign that mental health screen at the request of Mr. Romero, your attorney for today. And I'll provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, sir, you'll need to reapply to make sure they keep representing you. Anything else on his case that we need to address?
No, Judge.
All right, good luck to you, Mr. Waller. Yes, sir.
What was the bond on three?
3, oh, sorry, I wrote them down, but I may not have said it. On 3, it's 5,000. On 4, 1,000. No bond on 1. Leave the bond in place on 2. All right, thank you. Next on page 19 is Mr. Jones.
Approaching here at Main, Judge.
All right, thank you. All right, Mr. Jones, good morning, sir. Probable cause for robbery, no firearms or weapon or strong arm robbery. Mr. Linder, first to you.
Judge, I'm recommending a $5,000 bond, no victim contact. Mr. Jones is a career offender in the state of Florida. 2018 grand theft, sentenced to 25 months state prison as a habitual offender. He was most recently released from state prison August 14th, 2020. Additionally, another grand theft in 2018, same sentence as a habitual offender. Theft 2018. 2012, burglary, structured grand theft and possession of burglary tools, just under 41 months state prison as a habitual offender. 04, aggravated assault with a firearm, 2 counts, 5 years and a day state prison as a habitual offender and PRR offender. Delivery of a counterfeit controlled substance, 01, just under 19 months state prison. 99, attempted strong arm robbery with a violation of probation, just under 19 months state prison. There are other priors, Your Honor, but I'll stop there.
Thank you, Mr. Romero.
Judge, Mr. Jones is a lifelong resident of South Florida. It is correct. He was released from incarceration, but he's been out working for a year now. He works in landscaping. He lives with his father in Fort Lauderdale. My understanding is his father is 89 years old and depends on Mr. Jones as his caretaker. Judge, considering his lack of financial resources, we were going to be asking the court to consider a $2,500 bond and provisionally appoint my office.
All right, thank you. Mr. Jones, I'm going to set your bond in the amount of $3,500. The conditions of your bond, even while you are in custody and when you're out of custody, are that you cannot have any contact, direct or indirect, with the listed victim, even though you two are related. Do you understand?
Yes, ma'am.
That means you cannot call him, text him, email, social media, send letters, have a family member or friend send a message to him, or any other means of communication that I have not sent. Do you understand?
Yes, ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Jones. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else?
Nothing else, Judge.
Good luck to you, sir. Next is Mr. Fields on page 19.
He's here present, Judge of Maine. Good morning, Will.
Thank you. Good morning, Mr. Fields. I do find probable cause for grand theft auto. Mr. Linder, state's recommendation. Hold on, let me mute this. All right, go ahead.
Asking that the court keep the bond in place with an order of no victim contact. Mr. Fields was just released from state prison May 17th of this year. This is from a 2017 robbery by sudden snatching, where he was sentenced to 43 months in state prison as a habitual offender. Other priors include 2017 possession of PVP, VOP 43 months, petty theft 2015, possession of PVP 2014, trespass 2015, trespass 2015, possession of firearm by convicted felon 2010, 3-year state prison as a habitual offender, grand theft auto and criminal mischief 2010, VOP 3-year state prison, possession of cocaine 09, grand theft auto 09, possession of cocaine, oxycodone, tampering with evidence 07, burglary of a conveyance and theft 06, trespassing on school grounds, resisting without violence 06. Nothing further, Judge.
Thank you, Mr. Romero.
Judge, as you heard, he recently was released from incarceration. He's been actively looking for employment. Unfortunately, at this time, he's been unsuccessful, but he's still looking. Now, he's been residing in our community his whole entire life. He has a place to stay. He's living with his cousin in Fort Lauderdale. His cousin is helping Mr. Fields get on his feet. I know he advised me it's hard out there, but he's trying to do his best. Judge, on this nonviolent offense, we're asking for the court to consider releasing him on pretrial release because he cannot afford to post the $1,000 bond, which is currently set.
All right, thank you. I understand that, but he was released from prison not even 2 months ago, so I am going to leave the bond in place. Sir, you cannot have any contact, direct or indirect, with the listed victim. Even if you do not know them, you cannot call, text, email, send letters, have a family member or friend send a message to them. Do you understand?
As well.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Fields. Once COVID is over, sir, you'll need to reapply, okay? Good luck to you, Mr. Fields. All right, next is Mr. Ken Worthy on page 20. I saw them just log in. All right, sir, good morning.
Good morning, ma'am.
I do make a finding of probable cause for aggravated battery with a deadly weapon. I don't know the extent of the injury, so any objection from either party to deadly weapon?
No, Judge.
I would make an
I
objection.
will make that finding based on the no objection from the parties. Mr. Linder, first to you, sir.
Your Honor, I just need a moment to put his information in the system.
No, I see the weapon. I just didn't know the extent to make the finding for great bodily harm or disability as they presented it.
Might I ask how he's doing? Is he okay?
Yes. Don't talk about anything about the facts.
No, I know it. I just, it's something else. Oh, sorry. It's fine. You can hand it. Yeah, that's fine. You can hand it to the clerks. So yeah, that's fine because they'll just slide it over to me. Thank you. Are you still looking, Mr. Linder?
Yeah, Your Honor. Having an issue with DJJ and DOC. One moment, Judge.
DJ was born in 78.
I don't care as much about DJJ, Your Honor. The issue is I've got the spinning circles, and until that finishes, it won't let me look anything up. So
Okay, sorry.
Your Honor, but that's fine. Based on the level of violence, Your Honor, and the injuries suffered by what's described here in the report, Your Honor, I'm recommending a $15,000 bond, no victim contact, no possession of any weapons, no return to the incident location, which is In and Out Auto Services in Fort Lauderdale. Also noting that it would appear that this incident began because the alleged victim would not give Mr. Kenworthy money to buy beer. Nothing further.
Thank you, Mr. Romero.
Judge, I had an opportunity to speak with Mr. Kenworthy much earlier today. I know he's been here residing in our community for the past year and a half. He works when he can doing construction off and on, and whenever he gets a job or gets employed, he gets approximately $100 a day. At this time, he is financially indigent. He is homeless. He advised me there's no one that he can contact to help post his monetary bond. I'm asking to be provisionally appointed on his case, Judge.
Your Honor, I do have some additional information when it pleases the court.
Sure.
Your Honor, he had a warrant issued out of the state of New Jersey for failing to appear in court for child neglect. That was from December 12th, 2019. It's New Jersey pickup only. Getting hits, let's see, also out of New Jersey. Looks like there's another open case for fleeing and eluding, contempt, violating a domestic violence court order, and cyber harassment, sending obscene materials or posting obscene materials. Lording and prowling, 2009. Assault, 2006. Assault, 1999. Out of the state of New York. Escape, 2011. And nothing further, Judge.
What was your monetary request?
15,000.
All right, thank you. I misheard you. I thought it was something else. All right, thank you. Based on the allegations, the level of violence, the allegation that the victim was transported to the hospital and needed surgery, not knowing the extent of the alleged injuries. However, noting that they were so egregious that the alleged victim needed surgery and was covered in blood, as the reports indicate, I am going to and those prior failure to appear, the prior escape, and the other charges out of not only New Jersey, but New York. I am going to set bond in the amount of $15,000. The conditions of your bond, sir, even while you are in custody, you cannot have any contact, direct or indirect, with the listed victim. Although you may not know him, you cannot call, text, email, social media, send letters, have a family member or friend send a message, or any other means of communication that I have not said. Do you understand?
Fully understood, ma'am. If I may, I have no family. No, I have no family members. My wife, she was murdered by police officers. Me and her were military, Your Honor. I have absolutely no family. I'm going through a custody battle with my mother, who's friends with police officers who killed my wife. I would ask that if it is possible, if I could be ROR, Your Honor, and put on a monitor, an ankle bracelet, so that.
So, Mr. Kenworthy, based on the level of violence, the pending warrant out of.
Supposed violence, Your Honor.
To appear.
Supposed violence. This was not me that did this, Your Honor. Supposed violence. There's no proof of crime. There is no.
Mr. Kenworthy, you have a Fifth Amendment right to remain silent. Everything you're saying can be and will be used against you, and you're being recorded. Do you understand? So don't talk about the facts of your case.
I do understand. That's why I said supposed crime, Your Honor. I would ask.
And that you cannot have any contact, direct or indirect.
100%, 100%, nor would I want to.
All right, no contact, direct or indirect, no return to the listed property, no possession of weapons, firearms, or ammunition while your case is pending. Do you understand?
100%, Your Honor.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure that they keep representing you. Good luck to you, Mr. Kentworthy. Your attorney can always follow motion with your division judge, but I've already ruled. Good luck to you, sir.
Thank you.
1-5. Yes, 1-5. Thank you. All right, next is Mr. Kent on page 20.
He is here at Maine, Judge. Good
All right,
morning.
thank you. Mr. Kent, good morning, sir. I do find probable cause for battery on an officer, firefighter, EMT, et cetera. It's an officer. Count two, resisting with violence. Mr. Linder, first to you.
Your Honor, I'm asking that the court set $1,000 bond on one, 500 on two. Mr. Kent has a pending possession of cocaine with intent to sell, distribute, and methamphetamine from 2019. He had a trespass 2014, possession of cocaine 09, another in 08, and another in 08. Nothing further.
Okay, thank you. Hold on. Pretrial has information. Sorry about that, Ms. Brown. Yes, ma'am.
Yes, Judge. Mr. Kent is being supervised by pretrial on 1901248 CF10A, and his supervision specialist has submitted his warrant to the division judge
Oh, so it was already submitted?
today.
Okay, thank you. Okay, so I'm not taking any action since pretrial submitted that to his judge. Thank you, Ms. Brown. Hold on, let me unmute this. Bless you. Oh, sorry, I thought it was a sneeze. Mr. Romero, to you, sir.
Judge, considering pretrial submitted a warrant, but on the new law offenses before you, no objection. I'm going to be asking to be provisionally appointed on this case, though.
All right, thank you. I do have concerns though, because it indicates the alcohol influence box was checked out and these allegations stem because he was passed out in an automobile and they were so concerned that they had to call EMS. So I am going to put him on pre-trial. Does he have a place to live?
Judge, yes, he does. If he does, if the court is inclined to place him on supervision, I'm going to be asking if the court would consider then not imposing a monetary bond and consider pretrial on these two new offenses.
Level 2. Okay, he was already on a level 2 and should not have been out, Mr. Romero. So what I'll do is I'll impose the bond recommended by the state, 1,000 and 500, 1,000 on 1, 500 on 2. Once he posts bond, he's going to be supervised by pretrial release level 1 with a GPS. Now he's on strict house lockdown. If his division judge does not revoke, he'll be on pretrial release level 1 with a GPS once you post bond, sir. You cannot use drugs and you cannot use alcohol because you are going to be randomly screened for both drugs and alcohol at least one time per week while your case is pending. Do you understand? Sorry, I couldn't hear you.
Yes, ma'am.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. Is there anything else on Mr. Kent's case that we need to address?
Judge.
Yes, 1,000 on 1, 500 on 2. Pretrial release level 1. All right, good luck to you, sir. All right, next that brings us to page 21. Mr. Hidalgo is still a medical reset. He was supposed to be deleted yesterday for today. I'm deleting him again because he's still in the hospital. We'll only bring Mr. Hidalgo back, please, ladies, when he is released from the hospital. Okay, so next is we did Johnson. Next is Mr. Hernandez-Polanco on page 21.
He's here present, Judge Maine.
All right, thank you. Good morning, sir. I do find probable cause for a burglary of an unoccupied conveyance unarmed and a capias on count 2. Mr. Linder, hold on, let me mute this. First to you.
1 moment, Your Honor. The only prior I see is a 2019 felony criminal mischief. Based on that, I would not have an objection to an R order pretrial, no victim contact, and no return.
All right, so they're okay with you being released from pretrial today. Do you have a phone number?
Yeah.
Okay.
All right, so is that what he wants to do, Mr. Romero?
Yes, Judge, and he does inform me he has a phone number that he's prepared to give to the court at this time.
All right, so I'll have to do it on both counts since one is a municipal ordinance. Okay, so I am going to release you to pretrial release on both of these cases, sir. That means that you're going to get out today, but you have to call in tomorrow morning before 11 a.m. Do you understand?
I'm going to give you the phone number right now.
Yeah, they're going to give you the piece of paper with the phone number. We're not just going to let you guess it. So please give us your phone number so we can have it on file.
Give the judge the phone number nice and loud. Yeah.
Okay, 954 338 8871.
It is 954-338-8871, Judge.
Did you get that, Ms. Brown? All right, thank you. All right, sir, you cannot return to the incident location, the McDonald's. Do you understand?
I can't go over there no more.
Nope, you can't go back to that McDonald's. Do you understand?
Yes.
All right, you also cannot have any contact or indirect with the listed victim. That means that you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes, ma'am.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, sir. You're going to be released today. Please call in tomorrow. All right, next, Mr. Zaguri on page 22 is a medical reset. That brings us to Mr. Garcia on page 22. Is Mr. Garcia there?
Yes, Judge, he's approaching. Mr. Garcia, he's the advisory judge that advised me of private counsel Bradford Landers.
Bradford Landers. Okay, he's not here. All right, thank you. So, Mr. Garcia, have you or your family hired an attorney to represent you on this new law possession of alprazolam that's here in Broward County?
Yes, Bradford Landers.
All right, well, he's not here. So what we can do is either you can waive his presence and go forward on your own. You can waive his presence or you can ask that the public defender's office represents you for this hearing only. And then I'll say that you're going to hire your own attorney, or we can reset this 24 hours so that the ask the state attorney as a favor to call your attorney to see if he can be here tomorrow. But we're done with our docket now, sir. So what is it that you wish to do?
Judge, my understanding is speaking to at this time he wishes me to assist him.
He wishes to what, sorry?
Have me assist him for today's purposes.
Okay, thank you, because I cannot find a Bradford Landers in the Florida bar. So that was the issue I was having. I cannot find that attorney. All right, so Mr. Garcia, we're going to go forward with Mr. Romero assisting you. So I do find probable cause. Count 1 is possession of alprazolam. 2 and 3 are both out of county holds from St. Lucie County that I have no discretion over. You're going to be held no bond until you're taken to St. Lucie County to answer to those charges. So Mr. Linder, are you just asking that I leave the $1,000 bond in place based on the no bond hold?
Yes, Your Honor.
Okay, thank you. And Mr. Romero?
I'm not requesting anything at this time, Judge.
All right, thank you. So, Mr. Garcia, I am going to say that you will retain your own attorney to represent you based on that representation that you've hired somebody by the name of you're not. Oh, sorry.
I just want to say is maybe Beresford sounds more familiar because there is a Beresford Landers, and I just wanted to, if that's the case, I just wanted him to know the name. So if he had to tell someone else, they would know who to look for. Resford. He has an office in Lauderdale.
Okay, so if it's not Bradford, it may be Bradford Landers, Mr. Garcia, but it's my understanding you've hired him. So just look that name up so you can contact somebody to contact Mr. Beresford Landers, okay? Good luck to you, Mr. Garcia. You're going to be, St. Lucie County knows that you're ready for pickup, okay, once you post your bond. Okay, we only have one more case on our second look. It's Mr. Jones on a TC second look.
He's here, present.
All right, thank you. All right, so what can somebody tell me about this? It looks like it's a driving with operating without a valid license.
Yes, Judge. Mr. Jones was also being held no bond on a violation of pretrial for an attempted burglary of a conveyance. It would appear that he is he has pled that case out to probation. So now this is the only thing that's holding him. If he wishes to resolve, the offer from the state would be an adjudication time served.
Okay, thank you. Hold on one second. Let me unmute. Okay, Mr. Romero, what does your client wish to do?
Judge, he wishes to resolve the case today in exchange for his no contest plea.
All right, thank you so much. Mr. Jones, please raise your right hand for me, sir. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down and please state your name for the record.
Hello, Jones.
All right, Mr. Jones, it's my understanding you wish to resolve your operating without a valid driver's license case, correct?
Yes, ma'am.
And do you understand the charge against you?
Yes, ma'am.
Do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve this case?
Ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
Do you need more time to speak with your attorney, Mr. Romero?
No, ma'am.
Do you understand that you have a right to go to trial and fight this charge, but you're giving that up forever by accepting the state's offer?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
I'm not asking if you're a citizen. I just have to advise everybody that comes before me for a plea. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings, sir?
Yes, ma'am.
And how do you wish to plead? Guilty or no contest?
No contest.
All right, sir, accept your no contest plea is freely, voluntarily, knowingly given. I find there's a factual basis within which to accept this plea, and I'll sentence you to an adjudication time served. And Mr. Romero, how much time does he need to pay, sir?
1 year.
All right, and I'll give you 1 year to pay. Good luck to you, Mr. Jones. If nothing else is holding you, you should be released today. All right, guys, I think that's it for our docket. Do we have any questions?
Nothing else, Judge.
All right, everybody have a good day. Get some rest. Tomorrow's Fridays are usually big. Everybody have a good night.
Judge,
Yes.
I don't know if it's me. It sounds like I'm always screaming, but do you hear me? Can I speak softer or what?
Your volume is perfect. If you want to speak softer, do you want to try it now to see if we can still hear you?
Can you hear me now? I'm just speaking in a regular voice.
Speaking regularly, it's hard. It's hard. To hear you.
I'll keep on screaming. No problem, Judge.
Sorry, but we're going to go back to the old way. I'm doing the training this afternoon so that I can, because I've never done it with the system in the courtroom. So I have to let IT know that I'm ready now, and then they're going to come so I can fix it. Oh, Zoom will no longer be used on first appearance. I just got an email starting this Monday, the 12th. We're going off of Zoom, guys. We're cutting Zoom on Monday.
And Judge, then how are we going to deal with the quarantine then?
I don't know.
I know they still have the Zoom.
I just received an email that Zoom will now be dead starting Monday, the 12th. So this is tomorrow's the last day of Zoom.
Judge, is there any way you can talk to anybody that, as far as the people at quarantine, if we could still use the Zoom card for those isolated cases? I think we get about one person a week.
That's totally up to the sheriff's office. So you'll have to have your office reach out to them about what they want to do. But I just received the email from my office that Zoom is no longer going to be used starting tomorrow because it's too much interference. When we're all in the courtroom and all the feedback, it's really difficult to hear.
Okay.
So tomorrow's the last day of Zoom.
I'll let my supervisor know, Judge.
All right, thank you, everybody. Have a good evening, and we're going back to regular on Monday. All right, take care.